This is a Southern Sin breaking news special. Be sure to like and subscribe now.
One juror.
With AI,
you can create any character you want in seconds.
This used to require huge Hollywood budgets, complex software, and tons of time.
But right now, all you need is a laptop
and knowledge of the best AI tools.
It'll cost you practically nothing, and it doesn't require a subscription.
in just 2 days, I'll show you how to unlock the most advanced AI filmmaking tools without paying a cent in overpriced subscriptions. You'll learn how to create scroll-stopping videos that rack up millions of views, make profitable online ads that blow up your brand, turn any idea into a cinematic short film that looks like it belongs in Hollywood. But you won't only learn about AI filmmaking in this course. I'll also show you how to create viral thumbnails with AI. You can create a realistic clone of yourself in just 10 minutes. I'll show you how to generate graphics for your website, how to script viral videos using AI that sound exactly like you. Over 10,000 creators have enrolled in the AI Creator course, and their results have been mind-blowing. Like Dwayne, who started a brand new TikTok account with 0 followers, and within 2 months blew it up to 15,000 followers. And it won't cost you an arm to learn all this. Right now, contentcreator.com is having an insane Black Friday sale.
Yeah, one. Let me know when you're ready. All right. All right. What is it? You just waiting on it to crank up?
They're huge voice files because they're like hours an hour, so they're not. Mr. Lamb, I'd like to address some matters if you could step back to the
You can leave that there. I just want to.
Well, I just want to set it over here so I can use it while you're.
Okay. What I plan to do is, because it is morning, and I've gotten the impression from the jurors that they need breaks during the morning. And so, every hour or so during closing, regardless of where we're at, I'm going to take a pause for the jurors' sake. Brandon, at the back, I want to limit the incoming and outgoing traffic during closings. If I look at you and nod my head, I want you to go to the outside and don't let anybody else in except in between the arguments. Hopefully it won't be a problem, but I don't want a lot of distractions going back and forth while the attorneys are giving their summations. The other thing, the closing arguments are the part of the process where the attorneys, try to persuade one way or the other. So they're gonna talk, and they're gonna make argument, and it's gonna offend people that are in here that are interested in the case. I did not tolerate any reaction to those matters. So if that becomes a situation, then we'll stop, and somebody could end up being removed. And if you tell Deputy what I just said about the disturbances, so or about the coming and going. Sharon, can we check and see what the status is on the jurors? I know they're supposed to stick their head in and tell me. We're waiting on one juror, according to the bailiff, when I walked in. I also put I think Mallory gave you the verdict form for each of you to use during your closings if you wish to. Otherwise, is everybody ready to proceed? All right. As soon as the jurors are here.
Still waiting on the one.
Okay. When we have all 12 jurors, I'll come back in and we'll go right to close arguments. If anybody needs a break.
My energy bill dropped from $150 to $50 by doing this. Friends laughed at me when I spent $49 on a power saver device that could cut my energy bill in half. They thought I got scammed. But when I showed them my super low energy bill, they were blown away.
Check that out. This is our current energy bill. This is our last energy bill. And as you can see, over a 50% difference.
Hi guys, I just want to share a quick and simple technique that anyone can use to lower their energy consumption without changing their lifestyle. With this method, you can keep cooking, baking, gaming, running your dryer, wash at 90 degrees, and keep your heater running like you used to before. This method can essentially cut your energy bill in half by optimizing your home's energy grid. It lowers your energy bill by anywhere from 20% to 50% by bypassing the spikes in your home's grid, which can lead to significant savings on your energy bills. It was discovered by Carl, an electrical engineer, during last winter, when, like many of you, he was hit with ridiculously high electricity bills. His energy provider was charging him over $165 a month. It was insane. So he decided to do something about it. As an engineer, Carl knew the power grid we're all connected to isn't perfect. Billions of tiny energy spikes are
right now to the time. All right, you may proceed.
One moment to move this over. you make it up there yet?
This week, we're hosting a free trading and investing workshop right here in Atlanta. Inside this workshop, you'll learn you don't need to be a Wall Street pro to trade like.
Please, everybody, make sure that your phones are off.
Tuesday morning, I stood here and I told you that what this case was about was the short life and the horrible death of one precious little boy. By now, of course, you know who that is. It's J.D. Angeles, born June 25th, 2022. He died January 14th, 2024. The state, of course, has charged Trinity Poague with causing his death. She's charged in an indictment which contends that she committed several violations of the law, several huge crimes, beginning with cruelty to children, aggravated battery. For each of those felonies, there's a charge of felony murder. And then finally, there's a charge of malice murder. And when you get to the point where you're having to move from this, we have this fact and we have this allegation. How do you get there? And there's really not, the judge is going to tell you what the law is, okay, but there's not really in the judge's instructions. Typically, there's not really a roadmap for how you get there. And so what I would suggest to you, ladies and gentlemen, is this. And again, I mean, it is, you are free to decide the case however you choose to decide the case and by whatever process you choose. But I would suggest to you or submit to you that you might consider this process. And that is, you start with the facts that are on dispute. The things that you know that are established, where there's just not a realistic argument, where there's not a realistic dispute, where there's no controversy. Start there. And then the reason you start there is this, because you can resolve disputed issues in the way that is most consistent with the facts that aren't in dispute. Okay, so if you know that 2 and 3, that these two things are true, and then you're trying to decide whether this third thing is true or not, you can take that third thing and view it through the lens of what you know, of what you've already established or what you've already decided is an undisputed or undisputed issue. Once you've determined what happened factually, then you can apply the law to the facts. And of course, Judge Sizemore is going to give you a long explanation of what the law is, and he's going to tell you something very much like this. It's something that says to the effect of, you are the judges of the facts and the law, that you determine the facts, and then you apply the law to the facts to determine the outcome of this case. So for this part of my argument, what I want to do is this, ladies and gentlemen, is focus on some facts that are absolutely, at this point, indisputable in this trial. There is an indisputable medical fact in this trial, and that is that the cause of this child's death was massive head trauma. There's no question about, did he die because he had an infection? Did he die because he lost his leg and bled to death? Did he die for any one of these other reasons that somebody that might cause someone to pass away? In this case, the unanimous opinion of the medical the medical witnesses that you heard from, the physicians that you heard from. I'm not talking about Dr. Gamble now. I'm talking about the actual doctors, okay, who testified in trial. Michael Busman, who's practiced medicine in this town for 30-something years. You know, Jill Olin, who has practiced medicine in this town for 15 or 17 years. Dr. Anthony Clark, who has served as a medical examiner both in Georgia and Florida, you know, for the last 30-something years, who's done 8,100 autopsies, who's testified in court as an expert witness hundreds of times as to the cause and manner of death. They all agree this child died from the wound. There are other injuries. We're going to talk about those later in my argument, okay? But for right now, I want you to focus on this one. That is that it is an undisputed fact that this child died from head trauma. It's also undisputed that the trauma or the cause of the trauma is also undisputed. Dr. Clark says it was a tremendous impact to the back of the head. These are quotes I wrote down while I was listening to the testimony. He says it was a tremendous impact to the back of the head. Dr. Busman says it was a direct, high-impact blow.
Why you should never think you're too old to have a dog that adores you. My friends made fun of me when I ordered this AI companion dog, and now they're all asking me to buy one. I got this wacky dog, and honestly, I was ready to return it right away. Didn't expect it to actually feel like a real puppy again without the walks, the bending over, or the constant maintenance. But before sending it back, I figured I'd at least test it once, since I couldn't take care of a real dog at my age anyway. And guys, oh my God, this thing didn't just work. It completely brought back everything I missed about owning a dog. The happy greetings, the soft, the comforting presence next to me, all without the draining responsibilities I can't handle anymore. That's when I realized I wasn't just keeping it. I had to get more from my brother and my isolated area as fast as possible. I called their support team immediately. Hey, can I still get that 50% off promotion? They told me that since they're just launching, normally this deal would be over. Made a bit of an error and the deal is back. Apparently they completely sold out when they first launched, but then freaked out with all the orders flooding in. So they doubled production, made way too many units. Now their warehouse is packed and they need to move inventory fast, so they're running this crazy deal. But once their stock returns to normal, this promotion is good. And trust me, Waggy isn't just for decoration. This breakthrough technology performs beautifully. Instant companionship with greetings, tail wagging, head turning, breathing, realistic fur, gentle sounds, and more. All in one lifelike companion without a single monthly cost. Perfect plug-and-play setup, advanced AI emotional learning, quick bonding process, and the best part, it handles all your companionship needs by itself. Unlike those expensive real dogs that exhaust you and stack up vet bills month after month for no reason. Listen, that's when it clicked for me. Everyone was suffering alone because someone told them you need to keep caring for real pets just to have a companion. Waggy proves you can have dog companionship you want, all in one device without daily duties every morning. Waggy is the all-in-one complete ultimate solution you need for your emotional health and daily joy. This incredible device instantly lets you feel loved and needed without any real pet responsibilities at all. This amazing gadget transforms your lonely home without draining your wallet. Vet bills gone, dog food gone. Pure brilliant technology. You need to try it yourself. And with this incredible deal they're offering, grab a second one for your friend, or even a third for your family too. Why not enjoy companionship everywhere while paying nothing to care for a real living animal? It's perfect for seniors like us that can't spend thousands on pet expenses every year. It's not just a robot toy, but your ultimate companion device anywhere you go. Still not convinced? They've got a 90-day risk-free guarantee. Don't like it? Send it back. No questions asked. Just don't be foolish like me and try it first. But remember, once they clear the
There's not a question as to whether or not or how you get this kind of head trauma. In other words, it's beyond controversy. You can't get this kind of head trauma from bumping your head on the door back here, or you can't get this kind of head trauma because you have weak bones. You can't get this kind of head trauma because you have some rare childhood disorder like Paget's disease or Alagille disease or whatever it was that was brought up. Okay, rare childhood disorders, bone diseases, all these other things. None of those things will cause the trauma that this child suffered. To get this kind of trauma, it is an undisputed fact that it must be a direct, high impact blow. The time frame between the trauma and this child's death, this child's appearance at the emergency room and subsequent death, is also not reasonably in dispute in this case. Okay. None of these doctors who testified even allow for the possibility that this child's injuries were suffered the day before or the night before or even 3 or 4 or 5 hours before. They certainly weren't built up over time. It wasn't that he had a partial occipital and parietal skull fracture, with a massive hematoma at the back of his head and 3 or 4 other brain bleeds across his head, and that they just built up over some period of weeks. That's not what happened. The high impact trauma that this child suffered would immediately, according to Dr. Bussman, very quickly, 30 to 60 minutes at the most, result in essentially a full onset of symptoms. Dr. Olick said there is 0% chance of normal behavior from the time of impact forward. What are the chances? May I ask, what are the chances? What are the chances that this child could have sustained this blow and behaved normal for any period of time? And the answer was there is a 0% chance of that. Dr. Clark makes it 3 for 3. The time frame that Dr. Clark establishes this, he says that at a minimum, initial symptoms like drool, staggering, vomiting would have appeared very quickly, within seconds to minutes after the impact. He said, in his mind, you probably would be in terms of the original initial onset of symptoms. He says, in his mind, it's probably more like seconds than minutes before the symptoms begin.
Architectural Digest has asked this designer to refresh a studio kitchen in 3 ways, using choice products from IKEA.
I'm interior designer Mikkel Welch, and my design style is primitive, modern, and textured.
The winning proposal will be chosen by the teams at IKEA and Bon Appetit, and will be implemented in real life in our Bon Appetit studio kitchen. Which design will win?
My first impression of the space is that we have some good bones, but we definitely need a lot of work. What's unique about this particular space is it's the studio kitchen. So what makes a great studio kitchen is functionality, layered textures, and warmth for camera. You want that family watching to feel the emotion in the space and in the room. It really feels like home even through that screen. The design aesthetic for the first kitchen is very modern. We've got lime wash walls that are very reminiscent of Italian style design, and it creates a natural warmth in the space. For the island, I decided to use an accent color of green to bring everything together so it doesn't feel like a set. There's a lot of negative space in the kitchen. So the glass cabinet from IKEA totally hit the sweet spot. This is the perfect piece because 1, it gave me a lot of height. Having the glass prevents dust from getting onto your plates and your dishes, but best of all, inside of that glass cabinet are adjustable shelves. I am in love with the wine glasses from IKEA. I went with a faceted design, and it really kind of livens up the shelf that it sits on. Any kitchen that has an island definitely needs bar stools. I think the best solution here is to go with an upholstered stool that adds an extra layer of texture. So we have this beautiful cabinet, but it's still a little dark on this side of the room. So by adding these wall lamps, this really illuminated the space. They have this Art Deco feel, which really makes the space feel warm and connected. All right, final thoughts on this design. I think this is really strong. I'm loving the rich green wall texture that we have. I love the IKEA glass cabinet, as well as the textured bar stools. I think this is a really strong contender. So for this design, I'm thinking of that Avid cooker. They want access, they need functionality, and it all needs to be right there. I wanted to do an extension of the countertops and bring that design up the walls. That way, it just feels like the one harmonious wall that's very rich and soothing. I really wanted to zero in on functionality. So I went with an IKEA shelving unit where we could house all of the vegetables and herbs. It's like a one-stop shop and like a little mini grocery store. The cute greenhouse in the corner is something that's personal to me. I am someone who grows my own herbs, and I wanted to draw that same design that we had on the shelves over to the greenhouse. That way they tell the same herb story and everything makes sense. This kitchen has dark wood cabinets, so I decided to go with a black stool. It's functional because it's adjustable. It also plays nicely off the black shelving. Final thoughts here. I feel like this kitchen is a love letter to fresh food as well as functionality. This is a true chef and foodie kitchen. With the final design, I wanted this to stand out on its own. I wanted to go with a traditional countryside vibe. As a designer, I've worked with clients who prefer open shelving, but then there are others who like to actually have closed doors. So what's completely different about this design is I've incorporated upper cabinets and removed the shelves that were on the wall. White cabinets can be a little cold and sterile, so I decided to go with an off-white panel as opposed to a stark white, rich the space. Picking out cabinetry is one thing, but the real jewel in the room is going to be the hardware that you select. I decided to go with brass pools, and the thing that I love about these pools is it automatically gives you that countryside feel without being too stuffy. These really make the kitchen shine. As someone who loves to entertain, I need a ton of storage for extra dishes. This IKEA hutch I felt like was the perfect piece. It helped me balance all of the off-white that I have with the warm tones in the hutch, so it's just a nice balance throughout the entire kitchen. When designing a kitchen, you're dealing with a lot of hard surfaces, so it's nice to bring in something like an IKEA textile just to kind of soften up the space, and it feels like still part of the kitchen. Final verdict on this design. I'm a huge fan of the off-white upper cabinets. It's a huge game changer. The brass detailing, I mean, chef's kiss. And then when you layer that in with the textiles, as well as the warm tones in the hutch, this is a hard one. So for the first kitchen, I absolutely love the color story as well as the glass cabinet. For the second kitchen, I mean, this is a foodie kitchen, and I absolutely love that herb wall. For the final kitchen, those upper cabinets, big game changer, as well as the hutch. All three are extremely strong designs. There's so many possibilities, and I can't wait to see what they choose. Oh, wow. I had a feeling this was the kitchen that they would select. The adjustable shelves look so good. I mean, the herb wall and the greenhouse, this is so smart. This is what a foodie's kitchen should look like. Now, when they're cooking, they can just go grab a couple of herbs. They are going to have so much fun cooking in here. I can already see it. And even though this is a studio kitchen, there's so many practical things that someone could actually apply at home. If I lived here, I could cook here. So what I really love is that IKEA products for so many different design styles. I could not be happier with the end result.
All right, guys, this is the first ever action camera with a 1/1 inch sensor. So you get all your open gate, horizontal or vertical cross, and it also has a variable aperture. It's going to really help you focus low light filmmaking. So, yeah, it's pretty badass. And it's the DJI Action 6. Bring it. Keep it back. Look at all these chicks. I know you guys are used to me doing crazy shit in all of my DJI videos, but we're going to change it up for this one. And I'm going to vlog on the Action 6 because every time I've used the Action 6 for BTS or POV shots or anything like that, people don't believe me. It's an action camera because these cameras are that damn good now. Right off the bat, first giant upgrade on this is going to fix the issue that you guys may have just seen. That issue is on every action camera, the minimum focus is horrendous. And now that DJI put the largest sensor available for an action camera into the Action 6, it's going to make minimum focus even worse. But there's two solutions now. The first giant one is DJI Action 6 has a variable aperture. So you go from f2 and close all the way down to f4. When you close down f4, it's going to increase your close focus like crazy. Now, obviously, I was indoors. It was a rainy day. And so the f2 really helps for low light. So I had the camera in auto, and the camera was favoring the auto mode. Looking back, I should have put it at f4, or if I'm going to use Action 6 for vlogging and not action stuff for the day, I'm going to throw on their new macro lens. When you throw on the macro lens, you're able to get good as close focus when you're at f2, and then if you put it down to f4 with the macro lens, it's going to increase the close focus even more. On my bike shed, I frequent here a lot. I got to get a portrait of Will here.
Hey, oh my God.
So guys, the cool thing is, now that we have a square sensor, I can still place the camera vertically and still do a horizontal crop in post. So this is dope. One thing that is a bummer about all the DJI action cameras is they don't have.
Those facts have been established, ladies and gentlemen, by the evidence that you heard in this courtroom. Okay, you don't have to Google it. Okay, you don't have to have a discussion about what happened, when you were a child, or when somebody else was a child, or those. You don't have to talk about what people in the medical community really think. Okay, we're not talking about vaccines or something. Some people say, you should take them, and some people say you shouldn't, and all that. We are talking about medical facts as to which there is no disagreement. That brings you to this point. The question for you to answer as a jury is this: who could have caused the trauma that killed this baby within the time frame that it had to have occurred? Okay. No telling, in any number of things, any number of people, any number of circumstances could certainly have caused severe trauma to this child at some point in time. But that's not really the question. The question is, who could have caused this trauma within the time frame that you have available? There's an answer to that question. From 8:00 p.m. Saturday night, when we were in Albany, Georgia, on January 13th, 2024, until about 12:30 Sunday afternoon, January 14th, okay, for that whole time period, there was only one person who was ever alone with this child. There was one person who was ever alone with him for any period of time during that 16 and a half hours. You know who that was? That person was Trinity Poague. Not only that, ladies and gentlemen, when you focus on this time period and you reduce it down to the time during the time frame that the doctors talked about, the time immediately prior to the onset of the symptoms, the answer becomes clearer. One person was alone with JD during the time immediately before his symptoms appeared. That one person was Trinity Poague.
Keeping track of stock levels and sales used to be My biggest nightmare with my e-commerce store. Now, Xero makes it easy to stay.
At 11:55 a.m. on Sunday, J.D. Angelus was a healthy little boy. By 12:30 p.m., he was in a literal death countdown. It wasn't a question anymore as to whether or not he might live. It wasn't a question anymore as to whether he could be saved. It wasn't a question anymore as to whether he would ever be able to grow up. By 12:30 p.m., at 12:30 p.m., he was dying. There were symptoms that appeared during this time frame that appeared when Julian Williams, Jay Williams, when he pulled up to the dorm and he got out of his car and he went inside to pick up that child. Actually went inside to put down the pizza and the drinks because he thought they were going to have lunch. But when he went in and he picked up that child, there were immediate symptoms that the child was suffering right then. The child was essentially unconscious. Okay. The testimony is that his head was limp, that he couldn't hold his head up, that his body was limp, that his head was bobbling around. He was nauseated. Before he got to the car, or as he was getting into the car, the child threw up all over his daddy. He was draining CSF, cerebral spinal fluid. Okay, the fluid that circles your brain, that encircles your brain, that helps protect you from impacts, that helps protect your brain from shock, from harm. Okay, that fluid, by the time he got to the hospital, was literally coming out of his nose and his mouth. It was no longer contained here where it's supposed to be. It was here because of the head injury he had suffered. He was in cardiac or respiratory, cardiac and respiratory arrest at that time. When he got to the hospital, he wasn't breathing and he didn't have a pulse. Those symptoms go back to the time frame that the doctors established. Those symptoms would have had the impact that caused them, the impact that caused those symptoms would have had to have occurred within minutes before the child presented at the hospital. During those 35 minutes that we're talking about, okay, these 35 minutes, right, 11:55 to 12:30, during those 35 minutes, one person and only one person was alone with that child. Trinity Poague. To think about some of this, ladies and gentlemen. You have a circumstance where you have two people in a room. We see this in cases that get presented. I mean, I guess prosecutors everywhere see it at some point or another. You have two people in a room. One of them ends up dead. There's a fight. One of them ends up dead. Okay. You would think that's an easy case, right? Like you have two people, one's dead. Now we know who did it. Okay. But those aren't typically easy cases. And the reason they're not easy cases is because the person who is alive says, it wasn't my fault. It wasn't my fault. He attacked me. He threatened me. He did this, he did that. You know, I was fighting for my life. Or he angered me so badly that I didn't really have a choice. I was overcome by the emotion of the moment, you know. So it should be voluntary manslaughter or something like that. Okay. So there's a myriad of issues that sort of layer on top of each other when you have two people in a room, except in this circumstance, okay? Because the two people in the room during those 35 minutes were J.D. Angelus and the defendant. Those are the two people who were in there. There's not an argument that can potentially, possibly, in this universe or beyond, there's no argument that can be made that It was that it was caused by the child, that the child, was aggressive, that the child was the initial aggressor, that the child, attacked her and she had to defend herself. So it makes the two people in a room situation, instead of it being a hard case anymore, it becomes an easy one. I'm about to wrap up here in just a moment. Sit down and turn over the podium to Mr. Campbell. But I want you to think about something, okay? As you listen to him nitpick the evidence, and you heard the examination, you heard opening statements, you heard the examination of various witnesses, and so you already know it's coming. But as you hear him nitpick the evidence, I want you to keep this question in the back of your mind. What do any of these things really have to do with the death of J.D. Angeles? Did poor parenting, missing baby doctor appointments, using a car seat, did those things kill this child? No, those things didn't kill this child. Would testing a dirty diaper that came out of the dumpster or testing the vomit that was on Jay Williams' shirt and jacket, with testing those things, with interviewing some people in Colquitt, 50 miles or 75 miles away from, not more than 50, right? Like 75, 80 miles away from this happened. We're going down to Colquitt and interviewing some people. Would that put somebody else in the room with Trinity Poague and the baby? Would that have put somebody else in a position to inflict this trauma? No, those tests, those things, you're not going to get that. Did a bottle of rum or a dispute or fight over social media passwords kill that child? No. What killed that child was beyond dispute. It was a massive, tremendous blow to the back of his head that cracked his skull from here to here. So, there's a smoke and mirror show coming, though. I promise you. There's a smoke and mirror show coming. And I was thinking about this in terms of how do you see through smoke? How do you clear the smoke? Right? Firemen, there's a house on fire. Firemen go in, there's smoke everywhere. They have to get through. They have to navigate through. The smoke will kill them. I mean, if you just breathe it in, it'll kill you. If you just accept it, if you just let it be there, if you don't fight against the smoke, it'll kill you. So they put on goggles, and a face mask, with a breathing apparatus and a breathing tank so they can navigate their way through the smoke until it clears and they can get to whatever it is they're trying to accomplish. That question, ladies and gentlemen, that question is that provides your goggles. Okay? That provides your breathing apparatus for getting through and seeing through the smoke that's coming. That girl killed that little boy. She killed that little boy. She cracked his skull out of malice. We'll talk about all that later. She killed that little boy. She's the only person who could possibly have done it in the time frame in which it had to have occurred. Don't let these other things that don't have anything to do with the answer to that question, who killed J.D. Angeles? Don't let these other things cloud your vision and fog your mind. Thank you.
Thank you, Mr. Lamb. I'm going to let the jury step back in the jury room while the attorneys switch over their computers and such, and go ahead and take yourself respiration. We'll be back in 10 minutes.
My energy bill dropped from $150 to $50 by doing this. My friends laughed at me when I spent $49 on a power saver device that could cut my energy bill in half. They thought I got scammed. But when I showed them my super low energy bill, they were blown away.
Check that out. This is our current energy bill. This is our last energy bill. And as you can see, over a 56% difference.
Hi guys, I just want to share a quick and simple technique that anyone can use to lower their energy consumption without changing their lifestyle. With this method, you can keep cooking, baking, gaming, running your dryer, wash at 90 degrees, and keep your heater running like you used to before. This method can essentially cut your energy bill in half by optimizing your home's energy grid. It lowers your energy bill by anywhere from 20% to 50% by bypassing the spikes in your home's current, which can lead to significant savings on your energy bills. It was discovered by Carl, an electrical engineer, during last winter, when, like many of you, he was hit with ridiculously high electricity bills. His energy provider was charging him over $165 a month. It was insane, so he decided to do something about it. As an engineer, Carl knew the power grid we're all connected to isn't perfect. Millions of tiny energy spikes are constantly flowing into your grid. These spikes send excess energy into your devices, causing them to use more energy than they actually need. This is bad news for your appliances and your energy bill. Think of it like a bucket that's overflowing 24/7 without you even knowing. It's a massive waste, right? And of course, energy providers don't bother telling you about it or try to fix the problem. So that's exactly what he set out to do. Carl figured that if he could use Nikola Tesla's theory to streamline the current flowing into his home's grid, it would lower his energy consumption at the end of the month. So he built a prototype that uses the Tesla coil principle to stabilize electricity usage, cutting out all the spikes of energy you don't even use but still get charged for. He plugged it into an outlet in his house and let it sit there for a month. When he received his monthly energy bill, his jaw dropped. His bill went down from $165 to $62. It didn't just work, it was a massive difference. After
Gamble.
Good morning, ladies and gentlemen. This will be the last time that I have an opportunity to speak with you. I have as many as 2 hours to speak, and I can assure you it won't be that long. I'm sure you'll be glad that it will be. But what I have to say is important because some of the things that the district attorney said just a moment ago, I'm not going to try to address that particularly, except one thing he said was that this is an easy case. And when I first came before you, I told you this was a case in which the state had a case that was filled with suspicion, but empty on evidence. And then this is exactly what I mean. Would the state consider this an easy case that did not require any investigation, did not require much to be done, because they were so sure of who they thought it was that was responsible, they failed miserably in every phase of the investigation. And if you look at the evidence, the question that was put on the screen about whether or not any of this has to do with the death of the child, this is not a case about whether or not the child died. We all know that. If that is what the state needs to prove, we've done it. And we concede that. That is not what this case is about. This case is about the state of Georgia of a very serious crime of murder. And when the state makes a claim like that against someone, it is their sworn duty to prove it. And not just a little bit, but prove it beyond a reasonable doubt. That meaning that if there's any other reasonable explanation for what could have happened, any at all in your mind, you cannot come back with a verdict. Now let's look at what we have in this case. And I'm going to go through several things. You got to imagine I'm having to unwind quite a bit of evidence that's come through these last 4 or 5 days. But I'm going to try to take you through, not piece by piece who testified, but about certain things that matter. And the first one is, and a very important one is, that Agent Gibson came and testified. You remember, he is the person who said he is a crime scene specialist. He also has special training in crime scene preservation. He said he was told to go to a particular locations where they believe the crime scene occurred. That would be the dorm room at the Oaks of Trinity Poague, where also Ms. Williams had been staying and the child. Now we know when he went there that really quickly after arrival at the hospital,
The government is banning this $29 AI dog next month, and this is your last shot to get the original lifelike version. There's a new next-gen AI companion dog market, and it's so lifelike that people genuinely question if it's actually breathing. But here's the problem. In just a few weeks, regulators will force the only manufacturer to strip out realistic behaviors that make it feel alive. That means no more natural tail wagging, no more excited greetings, no more genuine companionship feeling that this incredible version delivers right now. The current version, called Waggy, is nothing like anything you've experienced before. That's because it doesn't rely on simple programming, preset reactions, or any official interactions whatsoever. Instead, it harnesses advanced emotional bonding, AI, creating a real attachment experience strong enough to crush loneliness instantly. Fully adaptive, completely touch responsive, recognizes your voice, and can provide comfort to anyone, anywhere, regardless of how alone they feel. Waggy was originally created for care homes because specialists needed a companion that would continue functioning through loss, sadness, and severe isolation. But now everyday people can finally get their hands on it. Major retailers like Amazon and Walmart already won't stock it because of how effective it is, and now regulators are moving in to restrict it even more. This current production run is the last time it will ever be available at full emotional responsiveness and bonding capability. Once the restrictions kick in, regulators will mandate changes to satisfy standard consumer guidelines, meaning reduced personality, diminished.
An officer was posted at the door, and it was taped off, and someone stayed there, and so no one came back to that room after Mr. Williams and Ms. Poague left that room. We know it, one, because it was roped off and had an officer, but also they got video. So we know if someone had come through in that dorm and tried to mess with anything from the time they left until the investigator got there. That's not possible. Investigator says that's right. So we don't have a question about, has there been a cleanup in this room? Has there been some tampering in this room? Nothing has happened in this room except the people left, and they left it in whatever condition it was in at the time they left in a hurry to go to the hospital. And what did he tell you about his investigation? He said he took photographs of everything that he saw in each room because they like to show the setup of each room to begin with and let you know everything that's there. And then his secondary purpose and most important purpose was to gather any evidence he felt was important to the case that could be used in this case to prosecute the case, whether it be against Ms. Poague, whether it be against Mr. Williams, whether it be against some third party, who knows, but to gather that evidence. And I asked him, in conclusion of questioning him, isn't it true that you did not obtain a single piece of evidence that was any use to you in this case? And he said, yes, that is true. I asked him, did you find any blood in that dorm room anywhere in that location, in that vicinity? His answer was no. Did you collect any type of human fluid that you thought would have been beneficial to tell you something? He said, no. I said, did you find any type of weapon in that room that might have been used, any kind of instrument that could have been used to cause blunt force trauma? Did you find a bat? Did you find a paddle? Did you find a statue that's sitting in the room that might be used? And his answer was, no. I found nothing that I think used. I asked him, did you find any place in that room or those couple of rooms where it looked like someone could have hit, an arm of a chair sitting out or a high countertop that might have a sharp edge, anything that looked like it could have been a child pounded into? Did you find anything that would have drawn your attention when you got out? He said, no. So what about the walls? Did you look at the walls to see? You would look at that. Yes, I would. Did you see anything? No. So we know that the state claims they have a crime scene. A crime scene in which they have obtained zero evidence from. I'm not talking about a little evidence, zero, unless you believe Agent Ford, I think, said they did get a receipt from Walmart. They went to Walmart to buy the drinks. I'll give them that. That's it. Nothing of evidentiary value from a supposed crime scene. Now remember, they said this is a violent, massive force injury. Yet there's no evidence within that room of anything that occurred like that. And I remember I asked the agent, so have you heard of luminol? A lot of people I know have heard of luminol. Luminol is used to spray it across the room in case you don't see blood evidence. Just because you don't see it doesn't mean it's been cleaned up or it's only a small spot and you can't see it with the naked eye. Spray with luminol, turn the lights down, turn on the light, and if there's any particular speck of blood, it'll light up. And I asked, did you do that? And he said, no, he didn't do that. He didn't offer an explanation why. He just didn't do that. It is inconceivable that someone, individually, intentionally, did harm to this child in that way, and it didn't leave some type of forensic evidence in that room. And remember, also told the child supposedly was throwing up on the way out of the room. And there was no throw up coming out of the room into the toilet. No evidence. The state is required to provide evidence. A defendant comes into a courtroom under the law cloaked in innocence, and it does not be removed from the defendant from the time they enter until they leave, unless some actual evidence comes in that can disprove that innocence beyond a reasonable doubt. But their crime technician, the one that's charged with collecting evidence, has collected nothing. So we don't know if that's a crime scene or not. We didn't get any evidence from it if it is. And we also know when I interviewed and questioned most of the arresting officers and DDI agents, anyone that was involved in this case, the autopsy people, all of them, we do know that the child suffered from blunt force trauma. We know that. But not a single person that I asked, number one, I asked each one, can you say, based upon what you saw, who did that? And the response for each of those persons is, no, I can't. I can't tell you from what I'm looking at, from what I observed and what evidence I had in front of me. I could not tell you. I could not say, yeah, I can tell you so-and-so did it. I can't tell you that I took ballistics from a gun. I can show it matches John Brown's gun. No. I can't tell you I found a weapon that was owned by somebody and now it's been used. And more importantly, I can't look at the body and tell you of a single mark that shows there's anything been done to it other than it has blunt force trauma, but not in the sense of you can see a paddle mark or a baseball mark or something that says.
David, the movie.
I will not be afraid.
Are you ready for a great adventure?
I will not be.
David, in theaters this Christmas.
What if employer-sponsored insurance didn't have to be group insurance? Group health plans often come with rising costs. And more importantly, healthcare isn't a group decision. It's personal. Even with the buying power of an entire business, group insurance still means high costs and limited choices. That puts businesses in a tough position and leaves employees with plan options that might not be the best fit for them. Or worse, no options at all. Now, a new form of employer coverage can help. ICHRAs offer the kind of control businesses employees need. They make costs predictable, thanks to a much larger risk pool and stable employer contributions. They make plans personal, because employees can buy any plan that fits their needs from any carrier on the marketplace. And they make coverage possible, because ICHRAs means some businesses now afford to offer insurance for the first time. So what exactly is an ICHRA? ICHRA stands for Individual Coverage Reimbursement Arrangements. And it means that businesses can reimburse each employee for the health plan of their choice pre-tax. Instead of picking from just 2 or 3 group options, ICHRAs provide funds for employees to spend on any plan they'd like. You choose how much to contribute, they choose what works for them. So if premium increases are a surprise each year and one size doesn't fit all, plan on predictable. Plan on personal. Plan on an ICHRA. Get coverage you control. Find out if an ICHRA is right for you.
Someone did this to this child individually. They have none of that. So they don't know who, but they also don't know how. I asked the I talked to people. I asked Agent Ford. I asked every one of them, do you know how? What happened? Well, they've got some theories. Maybe this, maybe that. I don't know. We just know the child had significant injury. So now we don't know where the crime scene is. We don't know necessarily who did it. And we don't know how they did it. We don't have any type of weapon. We don't have any type of instrument that supposedly caused it. And you're left with some speculation of, well, could it have been just the hands of someone, just the person themselves? Could they have done that themselves? And somehow grab him, somehow punch him. Good. Trinity Poague have done that. She have grabbed a child and done that with her hands. Well, you would think if that's a possibility that the GBI would have looked at her hands, photographed her hands, would have looked to see if there was any signs that she used her hands. Because remember again, this is a violent force, blunt force trauma. She used her hands to cause that. And you talk to her within a few hours of it, and you look at those hands, it's going to show. Whether they're going to show redness from blows, whether they're going to show scratching, whatever it may be. And it took quite a bit of pressure, of course, according to Dr. Clark and some of the others that testified. And we also know Mr. Williams was around the child. Who's more able to use great force to cause injury? Who knows who caused injury? But if there is injury, we do know Mr. Williams, nobody looked at his hands either. They didn't do anything to check that. And they didn't do that because they weren't going to check on Mr. Williams anyway. Because they were already down the rabbit trail they went down to begin with. That Trinity Poague is guilty and we don't need to look at any other evidence. Now you know that because I talked to Agent Ford, and I asked her about what their investigation do. We know that she talked to everybody that she knew in that dorm or had agents with her do so, interview them all, try to find out what they know. She got a phone. She got a phone of Mr. Williams. She did a few other things. She talked to different people. Well, then when I asked her about what efforts she made to try to find out anything about Mr. Williams or his sister, Shante Burr, what did they tell me? And the reason I asked that before I go any further, remember I asked that agent, I said, when you have child abuse cases, isn't it true that sometimes or often you find that a child has had injuries before the situation that leads to their death? They kind of show there's been abuse in the past, but now it's occurred. And she said, well, not all the time. And I said, but sometime, right? And she said, yes. And I said, isn't it important to then look, to try to see, to try to find out if that's the case? Now, she discounted and said no. Why did she say no? Because we already had a dead child here. I know it was in that dorm room. I don't need to look anywhere else. That's what she told me. I don't need to look anywhere else because I know where it happened. That's it. I don't need to look. I said, did you go to the house where the child lived and at least look at the house? No. I said, you wouldn't even know how to get there. Right now, if I wanted you to take me to where the child lived, and the answer is no, she wouldn't. Not even looking to see what type of condition was she living in. I don't know. No one knows. They didn't investigate it. Did they talk to any neighbors to see anything about the relationship going on? No. Did they talk to anybody that he worked with? No. Did they go to his workplace? No. Did they make any effort to find out? No. Because they'd already gone down that trail. And they decided at that point that this is the story we'll tell, and you'll see, and I'm going to talk about this a little bit, about the testimony being shaped to make sure it fits over here. And struggle and fight no matter what to keep it there. Because that's what they decided early on, and they don't want to break away from that. But now you have a case, you got no evidence. None whatsoever about how the trauma was occurring. You don't know for sure where it occurred. You don't know who did it, but they say it's an easy case. They say now we just got to look at it and we should be fine. But you know, maybe the most important witness that came in this courtroom was the one that's not tied up in connection with everyone else. That's Dr. Cosing. You know, the rest of these folks, they got some allegiance one way or another.
So all of you who own a timeshare, listen up. October 1st, all the timeshare companies are going to start sending out their annual maintenance fee bills. And if you're like most people who barely use their timeshare, it's like flushing thousands of dollars down the drain every single year. But here's the thing. You can get out of your timeshare legally, safely, and it won't hurt your credit. And no, you won't have to put any money down. There's actually a free guide explaining the whole process step by step. It was written by an ex-timeshare executive who is now exposing all their secrets. Click below to get that guide delivered straight to your door, but you need to act fast. October 1st is right around the corner.
Hi, I'm Charles Hoskinson, Chief Executive Officer of Input Output, and I'm here today to talk about the fourth generation of cryptocurrencies and one of the best products we've ever built in the history of my company. So back in the olden days, where the earth cooled, we had good old Bitcoin. And Bitcoin was a really magical thing. It took a long time to get to it, all the way up to 2009. And Bitcoin was really the first generation of the cryptocurrency space. And many of you who've heard me speak throughout the last decade will know how I talk about the generations. But really the problem that Bitcoin was trying to solve was this concept of decentralized value transfer. So when we look at decentralized value transfer in a digital medium, it was always possible to move value from one bank to another bank, one person to another person, but you always had a middleman that lived in between the people. And the problem with a middleman is that the middleman gets the power of the market. They get to see everything, they get to know everything, they get to decide the fees, they get to decide what to charge, they get to decide who gets to play the game. So what Satoshi Nakamoto was very interested in is, could we create some sort of instrument of value, in this case a Bitcoin, and can we create some sort of network that can transmit the Bitcoin to another actor? And it turned out that this was an unsolved problem, to do it in a completely decentralized, permissionless way. And nobody really believed that Bitcoin was going to be a thing until approximately 2013. Bitcoin kind of floundered in the beginning. Not a lot of participants, not a lot of value, but there were some very loyal adherents like the Hal Finneys and the Marty Malmies and the Mike Hearns and the Gavin Andresens and Roger Vers, who carried the torch and the flag, and they were able to get us to an inflection point in the history. So we went from first generation to $0 to $250 Bitcoin. Then around 2013, something very special happened. People realized that this concept of decentralized value transfer was going to be a thing. It's here forever. So then they asked a very natural question of, what do we do with it? What do we do? And they said, well, transactions and value, they're fundamentally unpredictable things. What instruments of value? Stocks, bonds, commodities, currencies, intellectual property. There are thousands of different ways that you can represent value. And for transactions, there's potentially an unlimited amount of ways you can express conditions of commerce. When you take a look at transactions, you say, well, there's one-to-one, person-to-person. It's the Bob. There's one-to-many, Bob to a whole country. There's many-to-one, whole country to Bob, for example, many-to-many. Look at transactions, you also have this concept of metadata around it. Good old metadata. The who, what, when, where, how, why. Where did you withdraw the money? When did you withdraw the money? You know, the geography that the money is based in. So geography. You have regulations. You have so many different considerations in addition to just the instruments of value that factor in transactions. So how can a fixed function system that only really moves Bitcoin in a very particular way ever hope to capture this entire universe of value that we have? Well, the idea of the smart contract came in. And this is similar to when JavaScript came to the web browser. Before JavaScript, web browsers displayed static websites. They could be very pretty, they could be very interesting, but they were static fundamentally. Then JavaScript comes, and then suddenly we have this dynamicism, and we get Amazon, and we get Facebook, and we get YouTube, and all magical experiences. So similarly, when we look at the dawn of the second generation, smart contracts became big. And this was most notably the dawn of Ethereum. But what we noticed right around 2015, as the paradigm started developing, is we noticed that while decentralized value transfer is great and having programmability is awesome, this cannot work for large groups of people unless you had three properties. One was scalability. Two was interoperability. And three is governance. So 8 years ago, I did a whiteboard video just like this one. And I talked about how this was going to work its way through back in 2017 at the dawn of Cardano. And since that time, years later, trillions of dollars of value has been created. Cardano reached a market cap at its all-time high of 100 billion, still it sits at 20. And there are 550 million people in the cryptocurrency ecosystem. Concepts like the blockchain trilemma were introduced to discuss scalability in a responsible way. Enormous work has been done on the interoperability side. And on governance, we have now complete on-chain protocols for things. When we look at Cardano, we're actually the world's largest DAOs. When we look at Cardano, we actually, with Ouroboros Leos and Hydra, have really solved the blockchain trilemma in terms of scalability. And these technologies are coming online either now or in 2026. And when we look at interoperability, a lot of amazing progress has been made with respect to bridging infrastructure, but also a lot of discussion of interoperability into the legacy financial world, up to including new laws that are being passed. So it's a very natural question to ask. Are we done? Do we have enough? Because at the end of the day, the entire point of all of these generations is to run the world's economic, political, and social systems. It's to take nation states and companies, to take your personal finances and run it in a blockchain, run it in a completely decentralized way. Because each step of the way, it preserves some fundamental values. From Bitcoin on, for real cryptocurrencies, no one's in control. No one can freeze your money. Nobody has access to your funds unless you give it to them. You own your own identity. You own your own personhood. You have economic agency. And the answer is no. So that's what we're going to talk about here today. The final generation, the last generation before we bring the billions of people in, unify the financial markets, and bring the entire world to the cryptocurrency space. It's been an amazing 16 years to watch Bitcoin evolve into concepts like Ethereum and concepts like Cardano. And it's been the privilege of my entire career to be here since 2010 and to watch all of these things for the past 15 years. But I'm most excited about midnight. And the reason being is midnight is what makes crypto real for everyone.
GBI can say what they want to. Dr. Clark's been working for GBI forever. And yeah, he's going to testify for the GBI. And you can bet your bottom dollar he's going to support whatever side he came in the court to testify about. He's not going to break off of that. And you got these law enforcement agents. They've already gone down the rabbit trail. They decided what they know. They're not going to break off. But Dr. Busman didn't have to be in this case, didn't want to be in the case. He had one duty and one thing he had to do. And that was he was an ER doctor, and he had to try to give some type of treatment for this child and see if he saved it. That was it. And then he got called to come testify. And he had to do that. I'm sure he didn't want to. As you could probably see, it wasn't that comfortable in testifying, but he testified. So you can bet he was trying to be truthful about that. And he told you some things that were extremely important. And one of the things that, as important as anything, I believe it's exhibit number, let me make sure I got the right exhibit here. Exhibit 26 It's a medical record from the treatment that he gave the child, came to the emergency room, and all that happened. And that record's already been introduced. It's an authentic record. You're going to get it back with you. You can look at all of it. And it's got some pretty important stuff that's contained in it. The most important stuff it's got that's contained in it. If you look at that document, I'm going to ask you that you do when you get the chance at the end of this trial, you're going to see that there are numbered pages. There's 2 sections of numbered pages. You look in, there's just a bunch of preliminary stuff with no numbers, maybe 20 pages worth, 15 or 20. Then you'll come up with pages 1 through 39. And that section of 1 through 29 on page 23, you'll need to look at. And then you'll see a second section of 1 through 28. And on that section, you need to look at page 20 and 21 of those. Now, why do you need to look at those? Because those medical records on 3 separate occasions say within the record that the father presents bedside and states the child fell around 5 minutes prior to arrival. Why is that important? First of all, we know from Dr. Busman that the only person bedside was the father. The girlfriend, Trinity Poague, was not there yet. So the only person, it's not a mix-up that they say. We know that because it's in this record. Now, what was interesting about that is you see how these states struggled so hard when they got up to pull that out of the record. To say, well, didn't that get entered a few hours later? I mean, that didn't happen right away. Trying to insinuate that maybe a mistake was made. Maybe that's not really what got said. On, and Busman, you can see they're most confused. Why is that happening? I'll tell you that's happening. Because they didn't like what Busman had to say, and they didn't like what he had to say because it's a lot more than just the father coming in with a story we know is not true. We know that the child didn't fall 5 minutes prior. Don't think he did.
My energy bill dropped from $150 to $50 by doing this. My friends laughed at me when I spent $49 on a power saving.
Or if he did, maybe the father knew it and we didn't know it. But they try to then claim that maybe Ms. Poague had told him that, and that's why he told the doctor that. Remember when I got Agent Ford up and started asking her about the interview she did with Mr. Williams? But before I put her up, I asked Mr. Williams, did you tell the agent when she first interviewed you, what you believe happened to cause the injury? He said, first interview, yes, I did. Second interview, I said, did you tell her? Yes, I did. And I put the agent up and asked her, can you tell me, here's your summary. You look at, do you have it from the first interview that first occurred when you got there, Mr. Williams? Yes, I do have it. It's 10 or 12 pages long. Okay. Can you turn to a certain page there and tell me, if you're looking at that, tell me anywhere do you see where Mr. Williams says what he thinks caused this injury? She said it's not there. In fact, what she read from that report was him saying that he came back to the room and asked Miss Poague what happened, and she said, I do not know. And then it said there's nothing else in the report. Now, first, the agent wants to avoid that too. She doesn't like that. She's protecting her story now, trying to make sure that we got the blame for Trinity. That doesn't fit the pattern. So she said, well, it may be in the report somewhere else. And what I told her, we got time. Read your report. Go through it. When you get through, let me know if you find it. Well, they sat here a few minutes, 5 or 10, but guess what? She finally said, I've looked. I said, you find it? She said, no. Well, then here came the real squirm. Let's say maybe I just didn't put it in the report. He may have told me I just didn't put it in the report. That's interesting. A trained GI that is taught that anything of importance will be put in a summary report to make certain that you're preserving that. We know that. We've heard testimony about that to some degree, but yet someone tells them because they believe of what could have led to the injuries to the child, and they don't put it in the report. But maybe they got told and forgot it. And she says that on the first one. Well, the second report, I asked her the same question, said, what did he tell you there? And he said in that report, absolutely, he did not know what happened. He didn't say, but my girlfriend told me something. He didn't say that I know something. He just said it didn't happen. So we know he was at hospital. No one had told him anything about a fall. That came from his idea. That came from his mouth. Now, if he got interviewed by GBI and he knew it, you can bet your bottom dollar in that only an hour or two after all this occurred, he would have said, yeah, the girlfriend said this. So we know that came from him, but we also know he didn't just tell the hospital that. Lieutenant Allen noticed. He came up when it was going on, remember? He saw him coming into the emergency room. He saw him standing in the doorway watching while they were doing the workup. He pulled him back and talked to him and asked him what happened and what he told him. That my son just fell face down a few minutes ago. Again, twice he's told that version. Twice he's told a different version to the GBI. And, you know, if you really get down to it, looking at some of the questions for Mr. Williams, let's talk a little further. Remember when he got on the stand, he told those two things that it seems pretty apparent that maybe they weren't exactly on the up what he was saying. Well, let's get to the third one. I asked him about being interviewed the third time. And the third time was important to me than some other people, but I wanted to know at the time that he was interviewed, did the GBI agent allow his sister to come in and interview with him in concert? And he said, well, yes, she came in, but when she came in, I left. I said, so you're saying if they asked her any questions, you left. And he first said he wasn't really asking questions, just looked at cell phone stuff. But then he said, no, it's asking anything. I left the room. That's what he said. That's what he told us, right down that witness stand. What he said happened. Now, it's important because, remember, I was asking the agent earlier. I asked her when we were talking about Mr. Williams and Trinity Poague, I said, when they were at the hospital, did you just interview them together? I mean, they were already there together. She said, no. And I said, why not? She said, of course not. I wouldn't do that. Why? She said, well, you know, it wouldn't make any sense. You would invite them up. And I said, that's because it's protocol from the GBI. She said, well, I wouldn't say it was necessarily protocol. I said, well, you think it's from training? And she said, well, I think training might have tell you to do that, but it's common sense that you would never put two people in together to interview them. I said, you wouldn't do that. No, I wouldn't do that.
Today, no college football playoffs. We're talking Georgia politics. Burt Jones, what are you thinking on him?
He is not serious. He spent more time in office helping the Jones family business than helping my family. I don't want that as governor. I can't trust that guy. I like Attorney General Chris Carr. Look at the film. He's an ally of Brian Kemp.
Tough on crime, just like Trump.
Chris Carr is going to beat whatever far-left nut job the Dems pick.
Welcome to Sage Kotzenberg's Eternal Descent. What are you waiting for? First, you gotta pick your player. Remain Rinikongas.
No niin, ja sit mennään. Ei muuta kuin lautakainalla ja menoksi.
Samper Dibbuck.
Yo, go Buck or go home.
Nils Mendenek.
Saddle up.
Zach Hale.
Shred on.
Dustin Craven.
Yo, should we take another down day?
Judd Hankins.
You're gonna want to ride hard and fast, bro.
Sage Kotzenberg.
Oh, you want to ride with us? All right, let's see if you can keep up.
Now we're ready to ride.
Stage dropping. Yeah.
Feel the hands that shape this world, then try to understand. When the light shines down and the time goes slowly, when my mind's in the dust, scorched and dying, there's a penny in my hand, inscribed to the sad and lonely. Now I feel so cold and alone, thinking how long. Now if you had told me she'd come back, and if you had told me the clock was gonna fall, if you had shown me some affection, I would have believed you. Don't tell me the moon is blue. Now you let me, 'cause tonight it's over. Now you let me, now the pain's in the dark. Now you let me, and you can't find your blue moon. Now it's over. Ooh, tonight it's over. again. Race to the ground, I do again. I'm lost. Path is unclear and the air is thin. I'm overlit. Everything here isn't true. Remember how words wasn't an echo to me. Your arms were just out of reach. Years so I was meant for no one. Remember when we saw her in the sand? Trees that bend shade for no one else. Wanting to see for myself again. I come to the ground next to you again. It was off, and it was years wanted to. And it's telling me everything here isn't true. It's coming down. She's a wasted promise. My arms are just out of reach. Years that go out for no one. Remember when we found comfort in the land? We reside on the trees that bend the shade of no one knows. Silent roots in a dusty haze. It's a desert that blooms in my darkest days. I am lost. Chasing thoughts in a dying living. I am over it. I'm dried up with love. sweet shade.
Dude. Oh.
Copy that. Sage dropping in 5, 4, 3, 2, 1.
There's a dream I've been saving for a day like today. Yellow trees, Indian waters, flowing softly on their way.
There's a dove in the treetop singing peace on the wind again and again and again. It's just a dream I've been saving for a day like today. Some hope I've been saving for a day like today. Love will come, love will conquer every heart that beats today. And it may not be perfect, but at least we can try. You and I, you and I, you and I. It's just some hope I've been saving for a day like today. There's a song I've been saving for a day like today. And the words tell a story of our young men far away. Bring them home, sings the chorus, for they're much too young to die. Must they die, must they die, must they die? It's just a song I've been saving for a day like today. Bring them home, sings the chorus, for they're much too young to die. Must they die, must they die, must they die? Just a song I've been saving for a day like today. Just a dream I've been saving for a day like today. Just some hope I've been saving for a day like today.
Now Mr. Williams talks about that. I brought the agent up on the witness stand. And I asked her about it. And she got amnesia. She said at one point, it's been 2 years, I'm not sure. Is that the standard we're using here for this case today? It's been 2 years, so I'm not sure. So everyone that's come in from the police department, well, it's been 2 years. I mean, I'm not sure we can depend on anything. If that's the case, it's been 2 years. I'm not sure. Are we to believe that agent hadn't reviewed her case file before she got here today? Yesterday, we testified, or starting on Monday, she just came in after 2 years and just winged it. You bet your bottom dollar she'd already looked at everything. She didn't want to talk about that interview. And then, when we refreshed her memory, what did the interview show? Almost 20 minutes, interviewed by themselves, 40 minutes with him and his sister together. Oh, it matters. Well, it matters about him and the sister who is keeping the child. We know from the evidence that the sister actually did more caretaking for the child than he did. She told me about that some too. Well, I couldn't say that. You know, he might have been some. Well, first of all, she can't say because he didn't do any investigation to determine But we do know a few things. We know that he came to the college at least twice a week, every week. He came every weekend, and most of the time without his child. 4 days out of 7, he is not at home, does not have his child. He has left the child with his sister. She is the caregiver of this child. Now, she's a caregiver of the child. There's some suspicion of any alleged abuse. It would make a lot of sense to try to separate people and talk about that some, not put them together so they can be interviewed and get their stories together. But that is a sign of what was going on here, that we're not worried about being any suspect. We've already decided this case. We decided this case when January 14th came by 5 o'clock in the afternoon. It was over. It may have been a couple more days before the arrest occurred, but the investigation had shut down and nothing else was going to happen. You were just going to have to live with it. And too bad. Why? Because we got suspicion. We got suspicion. Well, it's a scary world out there. If you're going on and just decide I'm a little suspicious and I can arrest you. It's a scary world. But you have that going on, but think about that sloppy investigation a little bit more. It's not just that problem.
It's biz, Ash. Great. With the help of Zero accounting software, I can keep my cash flow flowing by giving customers more ways to pay.
Such Zero with an X.
Remember when I asked the crime scene specialist about the dirty diaper? Now, we already knew that was coming up because we had filed a motion to ask to test the dirty diaper. We wanted to see if it had blood in it. And I've already asked Dr. Buzz about it. He said normally he wasn't sure that you'd have blood in your system from abuse, but I got to ask, but you could have some trauma at times that causes you to have blood in the system. Can you not? And he said, yeah, you could. I don't think the injury that's caused this death would have caused that, but it could be from trauma. It doesn't take a genius to figure if somebody punches you hard right in this area that you might end up bleeding in that area through your system. It doesn't take a genius to figure when you hear about boxers when they've been finished a hard 12-round fight that sometimes they break out the ring from for days on end. It doesn't take a genius to know that you got trauma in here, that you will have blood coming through, and it takes time. I asked Dr. how long? And he said, well, you know, you can't really say because obviously people's systems work different. Few hours to maybe a day or more. What does that mean? Well, it means there was blood in that diaper. We know a few things. It did not come off of that child on the day the child was taken to the hospital. The child had on a diaper different that they took off of that child at the hospital. There's pictures of that. So it was previous child went into the particular situation that led to the hospital. And probably many hours passed or even a day passed by. If it's many hours back, whatever had happened to cause that cannot have happened at the hands of Trinity Poague. Because we have a very short window of time you can claim Trinity Poague anything, which would be from 10 o'clock or 10:15 on Saturday night until 12 o'clock on Sunday, about 14 hours. That's the only time period she was around the child in that within a week or so. Well, why is that important? I mean, you say, well, that's not what caused the blunt force trauma. It's not. If you find that to be some abuse that caused that, it certainly would make you start looking a little further as to who might have done it. But if you choose not to investigate it, and worse than that, throw it away. So that this girl right here has no chance to defend it because the test that could have been run cannot be run because they threw it away. They knew it was a test they could run, and he got on the stand and tried to make like he didn't know that. I don't know anything about a fecal test. I've never heard of being able to test it to get for blood. I asked if you ever heard of the test, and he says, oh, no, I've never heard of it. And then he starts realizing, boy, that's going to be trouble, so what does he say? Well, I can keep a test for myself, and I can test for blood. If I'd have seen blood, I'd have tested it. He hadn't said anything about that the whole time I've been asking him. All of a sudden, he pops that one. Said, I didn't see blood in that diaper. Now, here's where Dr. Buzzman really comes in. It's really important. Why he's one of the most influential. Dr. Busman had no idea about the diaper. You could tell that when I asked him. I told him before I asked, you're going to find these questions a little bit weird or something that are, y'all tend to go on a path that you may not understand. And I asked him about those diapers. And I asked him if he had experience with blood fecal. And he said, yeah. Oh, yeah. I said, you probably tested it. Yes. Is there a test? Oh, yeah. So a hemocoat test. Easy. It's done. I said, is it done quite frequently? He said, well, I don't know about frequently. I said, but yeah, you've done it more than a few times. And he said, yes. I said, if you see what you believe may be blood or suspect that you're wrong, yeah. There's two ways I do it. Sometimes you can just see blood and you know it's blood. Other times you look and you say, well, maybe I better test it. And I said, so you can observe it, yes. And then, if you will, put up that diaper number 2. I showed him this photograph right here that you're going to be able to take back with you to the jury room. Oh, yeah, what again? I showed him this photograph that I'm talking about that he had never seen, had no idea about it. And my first question was, Dr. Busman, looking at that photograph, there appeared to be blood in the diaper. And he said, yes. I'd say probably so. Now, yes, that sent the state back scrambling again. They tried to rehabilitate that answer and say, but yeah, it could have been something else. And he finally said, well, yeah, maybe like if there was dye in some food, it might have caused the discoloration. But in his opinion, just eyeballing it, yes, that diaper seems to indicate. You can see right there on that screen, blood within it. He said, your crime scene technician didn't think that. Now, you decide which one you want to believe. That's your credibility issue of which one should be believed. Dr. Busman, who's done tests many, many times to test for blood, or this agent that decided to tell you all of a sudden that wasn't worthwhile. And it's interesting to note that diaper was not unfolded when he got it out of the trash. It was in a box. That was the first exhibit 1. You'll see that. He took a picture of that, and he unfolded them to take pictures.
Hey everybody, Walton Goggins here. A business is never easy, but with GoDaddy Arrow, that endeavor is about to become a whole lot easier.
Hey man, you got this.
You create a website that looks like you know what you're doing, even if you don't know what you're doing, because you're using a website, developed a tool that knows exactly what it's doing. It helps you design a logo. This is what we came up with. We put it here, we put it everywhere on our website, and we even put it right here. What I'm telling you, from one central command center, you can have all your social media empire operating. You're doing it all, everything fast. Let's go, Daddy!
So you know that he knew that might be evidence. There's no reason to open them up and take a picture. And after he got them, and once he saw what it looked like, he just chunked it back in the trash and left us with no way to test it. He left us with no way to test it. So he doesn't care about what Trinity Poague and has to say. He doesn't care about that at all because that doesn't fit his case. That wouldn't help him prove his case. That would hurt his case. He chunked it away. Chunked it away. It's inconceivable that was done. The crime technician tried to make like one he doesn't believe. You can take it down now. He does not believe that it is blood in that diaper, or number 2, that it should be tested. Because if it was tested, it would show, obviously, there was some issue going on with the child. Now, the other things could be going on. The child could have colon cancer, which would be almost unheard of for a 1.5-year-old child. Could have some type of ulcer, again, be extremely unusual. Child age. If that child that age is bleeding, other than right around the very bottom of the bottom where it might have had some kind of irritation, it came from trauma. And it came from trauma, and we came in the courtroom and show you that. Well, then you really got to wonder, why are we not looking? Why are we not looking a little bit further? Now let's talk back a little bit about the statements that no one's been alone with the child, with Trinity Poague. No, there's 2 people who've been alone beyond Trinity Poague with the child. Mr. Williams was alone with the child for a period of time. I'll talk about that in a second. And more importantly, the child itself was alone for a long period of time as well. You may remember the testimony of Mr. Williams when I had him on the stand on the day of, the morning when this all erupted. I was going to try to determine what was he doing and what happened. He said they got up in the morning. He didn't know the exact time. Nobody really gave me a time, but we do know he laid on the bed, and he said he put the child on his chest. And he also said at that time he had ordered the pizza that you know that he went to get. We've got proof of that. Well, you can assume then from that, we don't have concrete evidence of what he did, that he must have ordered food at some time getting toward the time he would normally eat. In other words, it's unlikely it was 8 o'clock in the morning he ordered the pizza. But regardless, he ordered the pizza. And once he orders the pizza, they did not eat the pizza right now, go get the pizza right away. He told us that he got up after being there with the child for a little bit, after having already ordered the pizza. And I'm assuming he's given enough time for the pizza to be made. He didn't want us to leave right away. He and Trinity Poague got up, took a shower together. And that's important in itself, together, because we know from the text messages you're going to see that are going to be introduced into evidence. One stream was to Miss Poague's roommate, where she's talking about, in one sense, on the Saturday night that she had told Mr. Williams, he wanted him to go home that night, but he wouldn't. And she said, but I want to go ahead and let him spend the night with JD, but she wants him to leave. I'll be the first to tell you, we've already heard a bunch of evidence that it was an on again, off again, I'm breaking up, I'm getting back together thing. And so I don't put a lot of stock to I'm broken up and necessarily saying that it was over. But it could have been what was going on. We know that Mr. Williams had been drinking the night before. He says only a glass or two after he got there with the child. Questionable whether that's true. We know that we have a bottle of liquor that only has about that much in it that he left in the dorm room, and we know Poague didn't drink it because he admitted she doesn't drink rum and wouldn't have, and it was his rum. But he tried to say that got drunk at some other time. How much he did have to drink that night, we know he went to sleep before everybody else. Saturday night, a young man, 10 o'clock already, and sound enough out that when the cry of a child that woke people up in the dorm at 1 o'clock or thereabout, he didn't wake up either time. So it's reasonable to believe he woke up hungover, not happy because his girlfriend is wanting to break up, and he might not have been in the best mood. Or it's also reasonable to assume that maybe the romantic breakup is being a makeup now because they're going to the shower. And if they go to the shower together.
My energy bill dropped from $150 to $50 by doing this. My friends laughed at me when I spent $49 power saver device that could cut my energy bill in half. They thought I got scammed. But when I showed them my super low energy bill, they were blown away.
Check that out. This is our current energy bill. This is our last energy bill. And as you can see, over a 56% difference.
Guys, I just want to share a quick and simple technique that anyone can use to lower their energy consumption without changing their lifestyle.
And they're young people, and they're making up. Chances are of them being in the shower for only 5 or 10 minutes is pretty slim. I mean, you go in the shower with your mate, it tends to make the shower a little longer for young folks, sometimes even for old folks like me. But I can tell you, when they go in that shower, they didn't stay in there just 5 minutes or 10 minutes. They are showering together, most likely doing other things. I'm not judging that. It matters to me. But what does matter about that? A 1.5-year-old child is sitting in that little pink chair that y'all saw a picture of earlier and will get a chance to see when you go back to the jury. And that little chair that sits there, it's not a danger to the child as far as I can tell of something happening in the chair. 1.5-year-old, I tell you about Miss Permont back in October. She was watching the child learning how to walk. He's a toddler, so now he's got a few more months under his belt of walking. I don't know what in the world that child may have done while they're in the shower. Do know this? They were probably in the shower for more than 5 or 10 minutes, 20 or 30 minutes. A pretty long time in the shower. They're in there. The child, I've got children. You got kids. My kids, when they were growing up, my 1.5-year-old boy, if you left him for a minute by himself without looking, he might be on top of a chandelier somewhere. He would climb and go and do all kinds of things. Who knows? Who knows what that child was doing right now? Who knows whether that child himself on that morning climbed up on something and fell back off of it? Who knows? But what we do know is that when the shower ended, Mr. Williams was the first one out of the shower. He testified to that right here and said he got out of the shower first and Trinity Poague got out next. Now, you can say, now, well, so what? He got out and immediately she got out. But he said something else. He said, I went and I was staying there with JD and I was waiting on her to get out of the shower before I left. Well, that tells you two things. Waiting is a term you would use if you're taking a little time. Not I'm waiting and she's following me out of the shower. But secondly, he told us as soon as she got out of the shower, he went to the shower and immediately left, so we know he was fully dressed. So he got out of the shower and got fully dressed before she came out of the shower. So there is a time period where he was the only one around this child. And there is a time period where I was alone and no one was there. Now, I can't tell you that something happened when that child was by itself. I can't tell you if something happened when Mr. Williams was there with the child. But I tell you one thing else. I can't tell you something didn't happen either. All I know is that was the situation. And so to say that there was no other opportunity for anyone, and the evidence they brought into court was if something happened, it would take anywhere from seconds to a few minutes for it to show signs. Trinity Poague gets out of the shower, the child's in the chair, he scoops out, she's getting dressed, she's cleaning up around the house, doing the things you do. It might take a few minutes. You can see up in the chair a little way. You might think a whole lot about it. If you go over there in 10 minutes, 15 and go, uh-oh, what's going on here? It's something that happened to the child, whether accidentally or maybe worse. But you can't discount that. You can't say that's not a reasonable proposition of what could have happened. It could have happened that way. And we don't know for sure. And we don't know because there's not been an investigation. There's not been anybody that's tried to push on those issues. They just said, we just don't accept it for what it is. We see they got a child that's not alive, and we're going to blame it on Trinity Poague. That's what we're going to do. That's what they did. And, you'll see that Trinity, and I'll talk about this a little bit later, but Trinity told people at first when this first occurred, she said that the child had fell off the bed. She had actually mentioned that the night before, talking to her mom.
Objection.
Let me not call, but said to text.
Facts, not
to text. I take it back. From the text message. She didn't tell in the sense of talking, but you'll see on the text message from Ms. Kermont, she said that the child had fell out of the bed the night before. And you'll see that she said that then. And so then you have not only her statement that happened, but I brought two witnesses in to talk about they heard a baby crying sometime between midnight, 1 o'clock or so, loud enough to wake them up. Now, these weren't even particularly favorable witnesses to me. They had some things to say that weren't all that favorable for Trinity Poague. They were important witnesses because they established when she said something happened that night, they fell out of the bed. Well, you got two witnesses that said, well, I'm right across the door, one straight across the corner, and I heard the baby crying enough to wake me up. Now, they both said the baby would cry a lot of different times for various reasons, but this was enough to get attention.
Hi, I'm Charles Hoskinson, Chief Executive Officer of Input Output, and I'm here today to talk about the fourth generation of cryptocurrencies and one of the best products we've ever built in the history of my company. So back in the olden days, before the earth cooled, we had good old Bitcoin. And Bitcoin was a really magical thing. It took a long time to get to it, all the way up to 2009. And Bitcoin was really the first generation of the cryptocurrency space. And many of you have heard me speak throughout the last decade will know how I talk about the generations. But really the problem that Bitcoin was trying to solve was this concept of decentralized value transfer. So when we look at decentralized value transfer in a digital medium, it was always possible to move value from one bank to another bank, one person to another person, but you always had a middleman that lived in between the people. And the problem with a middleman is that the middleman gets the power of the market. They get to see everything, they get to know everything, they get to decide the fees, they get to decide what to charge, they get to decide who gets to play the game. So what Satoshi Nakamoto was very interested in is, we create some sort of instrument of value, in this case a Bitcoin, and we create some sort of network that can transmit the Bitcoin to another actor. And it turned out that this was an unsolved problem, to do it in a completely decentralized, permissionless way. Nobody really believed that Bitcoin was going to be a thing until approximately 2013. Bitcoin kind of floundered in the beginning. Not a lot of participants, not a lot of value, but there were some very loyal adherents like the Hal Finneys and Marty Malmies and the Mike Hearns and the Gavin Andresens, the Roger Vers, who carried the torch and the flag, and they were able to get us to an inflection point in the history. So we went from first generation to $0 to $250 Bitcoin. Then around 2013, something very special happened. People realized that this concept of decentralized value transfer was going to be a thing. It's here forever. So then they asked a very natural question of, what do we do with it? What do we do? And they said, well, transactions and value, they're fundamentally unpredictable things. What instruments of value? Stocks.
So we also know that that happened. Now, she did say, when some of the records will show, they will claim, if you remember Dr. Wright, or Reverend Wright, said that she claimed that the child was in distress and fell out of the chair. Talking about that little pink chair. Well, if you look at the pink chair, you'll be able to quickly see she fell out of the pink chair and nothing happened. I would suggest to you, and I believe that I asked him about it as well, that what she meant by that is she noticed a child in distress, the child was slumping over, and it just sort of slumped out of the chair. That was not the cause of the injury. She was not presenting that to say it was caused by the child falling out of the chair. She was telling them, what do you know? Well, I came up, the child's in distress, it fell out of the chair. She wasn't insinuating. There were two different things here. Two different things entirely. You know, I had lots of questions I was asking about possibilities of falling out of a bed. And I know that some of the experts try to discount that to some extent and want to say, well, we're not talking about it. Time may not be right. I don't think that injury could occur. 40-inch bed is pretty high. 40 inches as high as my hips. You're talking about a small child that's 31 inches tall, falling onto a hard concrete floor. That child lands flat, bam, the back of its head, and have some significant injuries. But I asked Dr. to talk about it, and he was kind of waving around. But then I asked him, remember, about particular scientific journals and treatises. He didn't know I was going to ask him about it. I didn't know that he would know what I was talking about, but I asked him if he was familiar with Mary Case, Dr. Mary Case. She's a forensic scientist out of St. Louis County's forensic department. I said, is she well known? Yes. Do you know her? Yes. And I said, how do you know her or whatever? And he said, oh, I just went to a seminar, a week-long seminar with her. I've been to two. You can tell. He valued her opinion. And I brought that up because I wanted to point out a fact that was contained within that particular literature. And there was a particular page I turned him to. I'm going to read you about that page one more time because I think it's critically important. The paper was talking about accidents in which children had fallen from not particularly large heights, and it was severe enough that killed them.
Get the strong arm attorney John Foy and Associates. Big truck ruined your car and your career. Now the trucking company thinks they're going to bully you into a bad offer.
Don't get tricked, twisted, and trapped into a terrible settlement. Call me first. as a gigantic wealth fraud is uncovered in the Somali American community in Minneapolis. We discuss mass migration and what did Ilhan Omar know and when did she? Plus, we'll get to the arrest of the January 6th pipe bomber as well as economy talk. First, today is your last chance to get a Daily Wire Plus annual membership for 10% off. Don't miss our biggest deal of the year. Head on over to dailywire.com/cyberweek to join or give a membership right now. Well, it seems that the Somali welfare fraud scandal is now breaking into full view, and it's hitting a lot of people who are elected officials. That includes, of course, the governor of Minnesota, Tim Walz, but apparently it also includes possibly Ilhan Omar. So to understand why this matters so much, we have to understand this is all tied into a couple of major national issues. One, of course, is mass migration from third world countries. Is that something America should be pursuing? The second is a gigantic, unaccountable wealth state in which billions of dollars can simply go missing. It takes years in order to uncover all of that. And those two stories are intertwined. Obviously, when it comes to the question of mass migration, the Trump administration has taken an incredibly strong position that mass migration, particularly from countries that do not cohere to American values, that mass migration should be significantly limited or curtailed. The Wall Street Journal reports today, quote, work permits issued to immigrants who have applied for asylum or a range of other humanitarian programs will now be valid for 18 months rather than 5 years under a new policy announced Thursday by the Trump administration. Of course, the goal there is if people stay here for 5 years, they then tend to receive full asylum. They tend to become American citizens. If they only stay for 18 months, then it is easier to read cases and say, okay, well, now you can go back where you came from or to a third-party country. By forcing immigrants to renew their work permits more often, the government will have more opportunities to vet them, said Joe Edlow, director of U.S. Citizenship and Immigration Services. Edlow framed the change, which reverses a Biden-era policy, as the latest action by the administration to crack legal immigration in response to the shooting last week in Washington, D.C. of 2 National Guard members. That shooting, of course, was allegedly carried out by an Afghan national who had radicalized in the United States after being imported in the aftermath of the Afghanistan withdrawal by Joe Biden. It's clear that USCIS enforce more frequent vetting of aliens, Edlow said in a statement. All aliens must remember working in the United States is a privilege, not a right. So when it comes to the question of mass migration, now this is a very open question that has been implicated by not only that Afghan national shooting 2 members of the National Guard and killing 1, but also by this gigantic Somali welfare fraud case in Minnesota. As the Wall Street Journal points out, what happens when welfare becomes not a temporary hand up, but ingrained expectation in American life? For an ugly glimpse, look at the astonishing fraud unfolding in Minnesota. Turns out those GOP reformers were right to call out fraud in the One Big Beautiful Bill Act. The White House this week published a memo titled, Yes, There's Something Wrong with Walls, and it cost taxpayers $1 billion, highlighting various swindles in the land of 10,000 lakes. There may be as fraud as lakes in the state given the ease in which scammers tapped government funds. Some 86 individuals have been charged with defrauding Medicaid and the federal child nutrition program in Minnesota. Yes, literally stealing lunch money from kids. No one was doing anything about the red flags, one defendant's attorney told the New York Times. It was like someone was stealing money from the cookie and they kept filling it. In one of those alleged schemes, the outfit Feeding Our Future recruited individuals to set up a network of sham companies and sites that claimed to feed children in the pandemic. They then submitted false invoices and fake attendance rosters to the state. In fact, one of those rosters actually grabbed names from a website called listofrandomnames.com. And somehow this worked for years. In another scheme, a 28-year-old woman actually launched a company called Smart Therapy, claiming to provide one-on-one behavioral therapy to autistic children. She employed her relatives with no formal education. She recruited parents to enroll their non-autistic kids in her therapy sessions by paying them kickbacks of up.
And admittedly said it was rare. It didn't happen all the time, but from time to time, a fall would occur that would appear that wouldn't be enough to cause significant harm, but did. The first case study said that a 4-month-old male child was taken to a children's hospital. They did a CT scan, and it came back normal. He would not eat or sleep well. He survived for 2 days. They would then decide to take him to see his pediatrician and died on the way there. They said he fell out on an adult bed and struck the edge of the bedside table. So an adult bed, unless it's something really unusual, would not be 40 inches tall. A second one said a child that was 21 months old male. He cried after he had fallen. He was able to be comforted. He vomited, but then put back to bed after he was through vomiting. They found him dead in bed the next morning. he had fallen out of his own bed. A third one was a 7-year-old female who fell off a 6-inch tall tree stump, and she hit the back of her head. She complained of headache and vomited several times. Over the next 12 hours, she was found dead the next morning. And then finally, a 10-year-old boy fell off his bicycle, and he was found on the ground. He went to the emergency room. CT showed a fracture of the right temporal. That's all what happened, but he died. Now, these all involve subdural hemorrhages. The expert, Dr. Clark, wanted to try to walk away from that some by saying, well, wait a minute, those weren't caused by a fracture back here. They were fractures somewhere else in the skull, so that just sort of didn't count. Well, one of them did involve falling on the back of your head, but regardless of whether they were the exact same fracture, it's pretty good proof that time to time, a fall from not too high can cause significant injury. And if indeed that fall from the bed caused that, and sometimes it can't be discovered right away, and you looked at it, you see these examples, no one thought these children were in great danger. Two of them went to the hospital and were given the clearance to go home, and they died. This young lady, Trinity Poague, she's not a doctor. There was no visible sign, even according to the doctor, to the officer who first looked at the child.
Today, no college football playoffs. We're talking Georgia politics. Jones, what are you thinking on him?
He is not serious. He spent more time in office helping the Jones family business than helping my family. I don't want that as governor. I can't trust that guy. I like Attorney General Chris Carr. Look at the film. He's an ally of Brian Kemp.
Tough on crime, just like Trump. Chris Carr is going to be whatever left nut job the Dems pick.
All right, guys, this is the first ever action camera with a 1/1 square sensor. So you can get all your open gate, horizontal and vertical cross.
That was not in a real heavy area of what might be considered harm, where you would look at a child just visually and think something serious was wrong. In fact, even the autopsy doctor said, and the doctor at the scene of the ER said, you had to feel the back of the head to realize that it suffered an injury. If that child got an injury out of the bed at around midnight or later, it may have taken a few hours before it all of a sudden erupted and showed itself. Trinity Poague had no reason to think that was any serious injury. She would have no reason to. And she certainly would not have been the person that caused it. And if that's a possibility, and it certainly is a possibility, there's enough evidence to show that that most likely did happen when a child falling out of the bed. That's reasonable doubt as well. You cannot say that Trinity Poague was the cause of it. And I know, ladies and gentlemen, that you've heard some other things that you may have questions about Trinity Poague's posting of certain text messages that are in evidence already. She was in an immature relationship at 18 years old, 20-year-old man, and she made comments from time to time as they went back and forth with our up and down relationship that could have been said better. And she did at times she did not like the child, those type things. But never once has anyone said that they saw her in any way trying to in any way harm that child, including the father never said that. He never claimed that there was anything abusive going on. These were a matter of speech. It's much like if my wife were to go out shopping and come home and I thought she was buying a $100 coat and it was $1,000, I might call one of my friends and say, I could strangle my wife. She just bought a coat for $1,000. Do I mean I'm going to strangle my wife? Of course not. Poor language, perhaps, but just simply talking, in this case, mostly to Miss Kermont, who is her roommate, who is the person that she is very close with, who that she discusses her relationship. In fact, you will see in this thread of information on the text messages, you will see where in parts of this, Miss Kermont sort of agrees with her on stuff. She's talking about having trouble in State's Exhibit number 39, And she asked, is he sleeping with JD in your bed? And Trinity replies, probably. And she says, TRIN, that's so messed up. Make him get on the air mattress with his child. That's not your kid, and y'all aren't together. I know I told him after the night he better not contact me. Was Trinity's reply. This is a conversation between Permont and Trinity. So we know a few things with that little thread. First of all, Miss Permont's saying to her, you quit letting him just give the child to you while he goes and sleeps and does whatever he wants to and won't tend to the child. It's his child. Tell him to come be responsible for getting him bedtime and doing what needs to be done. So she knows that that's been an issue. And then secondly, officer plays asleep, and she says in return, after night, better not contact me, let you know it's on that downswing again. That's what I was talking about just a moment ago. And then all the conversations after that. But this is not proof at all of any type activity by Trinity Poague toward that child. You know, you don't have any evidence that Trinity Poague made any type of confession, which of course she did not. You don't have any evidence that she talked to some people after this event and has told them incriminating evidence somehow or another, and they brought it into court. Again, you have no evidence that says she committed this crime. You have the suspicion that she committed this crime that is given to you by the district attorney and then by the state of Georgia, that is to support it. Now, you also heard that she searched some items after she was at the hospital about skull fractures on her phone. And I want to be very clear so there's not any confusion about this. This is not a search that was done before the child had been injured. This is not a search that was done during injury of the child. This is a search that was done after she was at the hospital and after Dr. Busney met with her and Mr. Williams and told them that the child had a severe skull fracture and was likely not to survive. Now, at that point, you can look at this, and I'm going to tell you where to look on this, because I think it is very important that you see this as well. On those same documents, the one that's 1 through 39, the medical record, you look at page 38 of 39. It has a colloquy that shows at 1:15 that afternoon, spoke to the family to update the condition. That is when they meet and say, this is really serious. Trinity Poague, an hour or more later, and then 3 or 4 hours later, did search terms about skull fracture. What does that mean? And how can a child have skull fracture? That's very logical to assume you would do that. If someone told me my child had a skull fracture, I've seen nothing happen to cause anything to injure the head, I would wonder, how can that be possible? And I might even say to myself, well, I know he fell off the bed, not that high of the bed, but it's possible he fell off the bed and it caused it. And I would search. That is what happened here. This is not, again, the way the prosecution is portrayed. They want to try to make it some nefarious, evil thing that was done. Didn't thing that anybody can do. Check and try to find out what in the world all this means. Trinity Poague was 18 years old. She was living alone for the first time in her life at Georgia Southwestern College, and she'd been there a semester when all this happened. She came to the hospital after a traumatic event happened that she had no idea what was occurring on the child. It was in distress on things that she had nothing to do with. Did not know what was occurring. And then found herself within an hour or two being interrogated by GBI agents, by police officers, all that you can imagine, and her trying to figure out what in the world is going on. Now, ladies and gentlemen,
try to listen carefully, because we're going to run through the whole series right here for you, just once. This is Carson Hocevar. This is Jesse Love. And this is Raja Caruth. They're 3 of NASCAR's most exciting young stars.
Time to turn it up.
Each at a different step on the way to the same target.
Keep putting it to him, buddy.
Becoming the biggest names in their sport.
you've been sworn in to follow the law in this case, to make a decision on whether or not the state has a right to say that she committed a crime a serious crime. And your duty is to hold the state to their duty, which is they must prove that case, each and every element beyond a reasonable doubt. If any doubt exists whatsoever that is reasonable, you cannot convict. You cannot discount the possibility that Mr. Williams could have been responsible. You cannot discount the possibility that an accident happened to the child while they were showering. You cannot discount the possibility that falling before he went to bed caused injuries to his child. All of those are reasonable doubt. You cannot come back with a verdict. You know, this place that I'm in today, I'm been practicing law now for long enough, sometimes won't admit. And I've had many a trial, but it never changes in one respect. When I'm in a courtroom, this is hallowed ground. Where I am at right now is the bedrock of what we do in this country. We're kind of different in all other places in that we require when someone is accused of a crime that it be brought before a jury to make a decision, and that the proof of it is not just, I think you did it, might do it, more likely you did it, but you must have solid, no question evidence beyond a reasonable doubt. It requires that to be evidence. There's not been evidence at all. The state still doesn't know how it happened, where it happened, why it happened, who it happened, or even with what was used for it to happen. Do not make the mistake of allowing your emotions to be involved in this case so that you say, we must have a verdict some way because a tragedy occurred and I need a verdict. Do not, as I said in the opening of this case, in your rush to seek justice, do so on the cross of innocent blood of Trinity Poague, who has not had a thing to do with the injury that occurred to that child. It was a tragedy that occurred for reasons that I will not stand here and tell you I know the reason. But the interesting thing is, they don't know either. They know it's a death, they know it's blunt force, but for all the reasons I've told you before, they do not know. I trust you when you go back to the jury room that you will consider the law. You will consider the evidence, or in this case, the lack thereof, and you will return the only just, the only righteous verdict that Trinity Poague is not guilty.
Thank you, Mr. Chairman. I'm going to give you a 15-minute recess. We'll come back at 12. Let's make it 12:10. 12:10. We'll come back at not 12:10. I'm sorry. 11:10. 11:10. We're clear on that. 15 minutes, basically. Thank you. All right, Mr. Lamb, you can conclude your argument.
In the way back, probably just shows how old I am, which is old. In the 1980s, there was a movie called Scarface, and the guy was like a Cuban guy who would become a drug lord in Miami or whatever in the 1980s. And there's a scene in there where he gets caught. Not for pushing drugs, but he gets caught for laundering money, like trading money for, the swapping it out with somebody else for, percentage of the profit in order to account for all the millions and millions of dollars in cash that are coming in. So he gets caught, his own video and all this, So he hires a lawyer, and the lawyer comes in and looks at him, and the guy says, I want my rights. I'm presumed innocent. I'm not an idiot. And the lawyer looks at him, and he says, under the law, he says, to be convicted, he says, the government has to prove that case beyond a reasonable doubt. And he says, and Tony, honey baby, he says, I am an expert at creating that doubt. And he says, but it's awful hard to do when you're sitting there and there's no other explanation for you having $2 million in 20s rolled up in duffel bags. And that's sort of the situation that we're in here. I understand Mr. Gamble's a great lawyer. I mean, he is. He's an excellent lawyer, and he can find these things he created. And that's why, literally why, I ask you, so when you listen to this, when you listen to this nitpick, wait for an answer to this question. What do these things really have to do with the death of this child? And we're going to talk about it. We're going to talk about the poor parenting and the dirty diaper and the vomit on the jacket and all of that as we get further in. But first, ladies and gentlemen, what I want to do is I want to talk to you about what the charges are and what I have to prove. Okay, these are the charges that are in the indictment. Okay.
You think you know David's story. A boy.
And I'm sort of starting actually, I think I'm starting kind of in reverse. I should have gone back and put them in the order of the indictment, but there's a reason that I wanted to do them this way. And that is that I wanted to start with what's kind of the underlying felony charges, which then, go up the scale as you add other things. So aggravated battery, the state has to prove the defendant maliciously harmed the person by rendering a part of his body useless or seriously disfiguring a part of his body, which the evidence in this case establishes that J.D. Angelo's brain was essentially rendered useless, that his liver was rendered useless, his liver was disfigured due to massive lacerations, and so forth. For first-degree child cruelty, the state has to show that the defendant maliciously caused cruel or excessive physical or mental pain to a child. Now, both of these charges include the phrase malice or the word maliciously. And the law, and this is what Judge was going to charge you to all of these things. That's the reason I'm putting them up now. And I think you may actually get a copy of the charge with it. And if you don't, if there becomes a question and you think, we need to be clear on this point of law, all you got to do is say, hey, Judge, can we get a recharge on this or that? And they'll come back and tell you this again. But malice is not necessarily ill will or hatred. It simply means an intent to cause pain without justification or excuse. Malice also means willfully, intentionally doing an act while aware of a strong possibility or strong likelihood that pain may result. If you pick up an 18-month-old baby and you slam him down on a piece of furniture or on the floor or against the wall, with the degree of force is necessary to fracture this bone, with the degree of force, in a separate blow, the degree of force that is sufficient to tear his liver practically in half, then folks, that's malice. I mean, because you can't do those things to anyone, particularly not to anyone, a child or anyone, without knowing that it is a strong likelihood that pain is going to result. So if you find Trinity Poague guilty of aggravated battery or cruelty to child in the first degree, and I submit to you that you should find her guilty of both of those charges. If you do, then that brings you to felony murder. And what felony murder is it says a person commits the crime of murder when in the commission of a felony, he causes the death of another human being with or without malice. Okay. So in other words, it's not a matter of did somebody intend to kill him? Was somebody aiming to kill him? Was it a specific, I'm going to, I've got an hour, I've got 30 minutes, I'm going to kill this baby right in a minute. Kind of thing. Don't have to prove that. Okay? Don't have to prove a specific intention or intent or desire to kill. All you have to prove is that the felony, the underlying felony was intentionally committed with the person knowing that it was likely to cause pain And if you do, then that leads to the finding, I think almost necessarily, I say I think, and not I think, but you know, there's, when you look at it, how do you analyze this? You find the felony, and then you look at this charge, which says that if a person dies in the commission of the felony, then that's murder. Well, that's exactly what happened here. And that circles back to where we were at the beginning of my first part, which is that the question is who caused the trauma that killed the baby within that time frame? I mean, that ultimately will answer those other questions, okay? Because if you know the answer to this question, then you know the answer to to whether the defendant is guilty or not guilty of those other charges that have been brought. I fully understand, I respect, and I honor the burden that I come in here with, and the judge is going to charge you, and there's no question about it. Mr. Gamble argued it absolutely right. The defendant is presumed innocent, and that presumption carries with her throughout this whole trial. It carries it. She had it. She came to this courtroom. Okay, she has it when you go to the jury room. Okay, but when you look at the evidence and you find that evidence is sufficient to overcome that presumption, when you find that the evidence is sufficient to show you beyond a reasonable doubt that she's guilty, then the presumption goes away. Until then, she certainly has the benefit of it. The law says that nobody can be convicted of a crime unless the case is proven against them beyond a reasonable doubt. We have to prove all the elements of the indictment in order to do that. The evidence in this case is
Hey everybody, Chris Broderick here, and you're at Jackson checking out my Chris Broderick Signature Series SL 6 and 7 model guitars. As far as this model goes, its initial inception was based on a guitar that I built when I was in high school. And I loved asymmetrical shapes, and I wanted something that looked like it was in motion. And so that was the initial version that came out. And with this revision, actually, the coolest thing is we were able to streamline it a little bit and make it look, I think, even a little bit more in motion. And at the same time, we lightened it up a little bit. So I think it made it much more playable, much easier to sling around when you're on stage. The color is trans black. I've always loved trans black, and I always love wood finishes, and flame maple is always gorgeous when you look at it. So I love it. It's got a lightly subdued look to it, but it still makes a statement. So it was
not. It's not as complicated as Mr. Gamble wants you to think it is. It's actually fairly simple at this point. And that is, okay, we start on Saturday, January 13th. Jay Williams was in college. JD was with him. He had been up here. He'd been up here earlier in the week. He'd stayed here like Thursday night, Friday night. Okay, he'd stayed at her dorm or in a motel, whatever, at Hampton Inn Thursday night. This is his testimony. He stayed in a hotel there. She'd come over, and then Friday he was going to stay in the hotel again. And she came over, and when she came over that time, and she didn't want to stay. She said because they're breaking up. She's breaking up, right? She wants to leave. She wants to go. She goes back to the campus, and when he doesn't come with her to the campus, she calls him or texts him and lies to him about having been in a car wreck. She lies and says I was in a wreck. And he told you that Of course, his reaction to that was is he took off to the campus, to check on her, and she wasn't a wreck. She wanted to talk to him. In fact, it was sort of reverse stalking. Like instead of following somebody, he said, "Here, come here and follow me." And that's exactly what she did. And so on this day, the next day, January 13th, she's in Americus, he's in Colquitt. She wants to go to Chipotle in Albany. Okay, so she asked him to meet her there. He doesn't call and ask her out on a date. He's not planning on going anywhere, and that's what his testimony shows. The reason that he wasn't planning on going anywhere is because he was going to be home with his son, with JD, and nobody else was there. His sister wasn't there. Didn't have anybody else. He didn't trust anybody else to keep JD, and so he tells her, he says, "I'll come, but I've got JD with me." And she says, "Well, come anyway. Just bring him with you." They get there, they eat dinner, they go to Sephora. She swaps the car seat from his car to her car because it says that according to his testimony, she says that she would maybe give her a little time to spend some time with JD, while she's driving and work on building some kind of bridge or relationship with him, etc. So then she says she wants him to come back to America with her. And the car seat's in her car already. And he says, "Yeah, okay, I'll come back to Americus with you." Okay, so at this time, when they're in Albany, okay, this video is it's one of the videos that was played. I mean, it's not a video, it's a screenshot of the video, okay? But this shows the child in the car. Okay, this is when Jay Williams has left Colquitt and is coming to Albany. That video is taken, okay, and he's wearing his little Nike, his black Nike is what I'm trying to say, black Nike hoodie and not hoodie, jacket and pants, his suit, tracksuit or whatever. It's the same thing that Jay Williams was wearing himself. He made reference to it that was they had matching outfits. Okay, this is what this child looked like, though. Okay, there's no bruise on this side of his face. There's no marks on this side of his face. His face isn't swollen or anything else. That's what he looked like when he's in Albany. Okay, now.
What is going on, you guys? Welcome back to the channel. Back with another video, a review of the all new DJI Osmo Action 6. I've been waiting for this camera for a very, very long time, so shout out to DJI for handing me this camera early on so I can review it, because I obviously love filming and action cameras are the main component, besides of course the motorcycles, of motovlogging. So I'm always very excited when the new flagship best camera is out on the market for me to test out, review, and this is going to be that video for you guys, as a camera just released today. I'm currently shooting with my good old Osmo Action 5 Pro. Now we're about to switch to this beautiful brand new DJI Osmo Action 6, and just like that, out with the old, in with the new. This is the good old Action 5 Pro. Ton of videos were filmed with this camera, been non-stop using it ever since it got released. If you guys didn't know, I used to actually use GoPros for the longest time when I started my channel, and I only had one.
There are these claims that were made in opening statement, okay, that turned out to just simply not be true, okay? In opening statement, the defense says that Jay was drinking when he met her in Albany, and she just couldn't send JD back to Colquitt with him. So that's why she took the child, and then she let them come to America with her because they wanted, they wanted to go to Americus or Jay did. That's what you were told here. There's no evidence that says that. There's no witness who testified to those things that you were told you would hear. In fact, what happens is on January 13th, look, after she has asked him to drive from from Albany to Americus, okay, before she's even back at the dorm, she texted Paris and she says, "Are you coming back? I got stuck with JD." Paris says, "Yeah, I'm coming back." And she says, "It made me feel so bad because it's already late and JD is being so fussy." So he asked if they could stay. And ladies and gentlemen, there's just no actual evidence that is what happened. And in fact, it doesn't make any sense, y'all, that he would have done that, because if he's in Albany, he'd be closer to home than he would be to here. So on Saturday, then what happens is this. They get to the dorm, they go through the door, and you saw the video from Georgia Southwestern. The doors at 10:06. He testifies that he blows up the air mattress for Poague and JD to sleep on. Trinity Poague are going to sleep on the air mattress. And there's not a lot of explanation for why that is, but the context, some of the other messages that we'll get to later, and I think the testimony of Paris in this trial suggested that typically when JD was here, that he would sleep on the air mattress with Miss Poague. That night, Paris came to visit them. Okay, she wanted to see the baby. She left work on her lunch break. She came to see the baby. She says that when she saw him, he was perfectly okay. He didn't have any bruises. He didn't have any marks. He didn't have any tenderness or soreness. She picked him up. She hugged him. You know, they kind of played around, and he wasn't tender, he wasn't shy, wasn't any of those things, okay, because he hadn't been harmed at this point. He doesn't have any bruises. He doesn't have any injuries. Jay Williams fell asleep on the bed watching TV. So let's take a pause here and think at what's the baby's physical condition at this time, okay, which is 10:30, 11 o'clock on Saturday night. There's no evidence of bruising, pain, soreness, or any injury. The only thing that was said was he might not have been hungry. There was some allegation that he didn't eat much. Of course, Mr. Williams said the reason he didn't eat much at Albany or wherever was because he had eaten in Colquitt before he came up here. Then that night at 11:46, Ms. Poague texted Paris and says, "Is it okay if I watch TV in your room?" She says, "Yeah." "Why, are you all right?" She says, "Yeah, I need a break, a mental break. JD isn't asleep, and Jay is knocked out all over the bed, and I didn't want to play the TV." Is what she says there. So 11:46, she's asking Paris if she can go to the other room with JD. So it goes Sunday morning. This is Jay Williams' testimony. He woke up. They woke up. JD she had gotten into bed with him off of the air mattress. They woke up. He said he woke up somewhere around 9, maybe something. Said she woke up like between 9 and 10, I think. Says that he picked up JD and he put him on the bed with them and he laid him on his chest for a little while and whatever, and then they got to take a shower. Okay. Now, the allegation is that the statement from Mr. Gamble is that he says that they ordered the pizza before they got in the shower. The testimony, and you will recall it, of course, was that they had talked about ordering pizza at like 10 or 10:30, but hadn't done so. And then they ended up actually ordering pizza, a little while later. And whether it was before or after they got in the shower that they ordered the pizza, don't know, but it doesn't matter. Okay, he gets out of the shower, he gets dressed, he says goodbye to JD, he leaves to go to Walmart and Pizza Hut, and at the time he left, and at the time Trinity Poague got out of the shower and went back in the room, JD was in that pink chair watching Katuri, a kids show on TV, and had a Mountain Dew and some Fritos Twister chips. Okay, so when Jay Williams leaves at 11:55, what's the child's physical condition? Again, no evidence of bruising, pain, soreness, or any symptom of injury. He might not have been hungry.
Jesse Love will win the first race of the 2025 Xfinity season.
Dad, we want to
Drop shot to the big hit to the inside retaining wall.
You need to have the results, right? But ultimately, I'm either good enough or I'm not.
I'm pushing pit road. Shouldn't have turned it off.
Wanted this, got there, and now I'm gonna beat him.
That didn't come out very clearly, but that's at his worst condition if you hear the evidence. Okay, he's gone from 11:55 to 12:30. When he's turning back into the parking lot, he got back-to-back calls from Poague. She didn't tell him that anything was wrong with the child. What she did was she called and hung up, and then he said as he was parking, he was about to get out of the car, she calls back, and she's not talking to him. She hears him, hey, JD. So he gets the pizza in the Walmart bags, and he goes into the college, into the dorm. You saw that on video as well. And if there's any portion of those that we can't send videos to the jury room because there's no way to play them there. But if you should decide that you need to see them again, all you have to do is ask, and we certainly, the court will make arrangements for that. So he goes in the room, she's holding the baby. He realizes that there's something wrong with the baby, and he did. He testified that he asked, what's wrong, and didn't testify real clearly as to what she said in response to that. We said what's wrong, but he wasn't waiting around to find out. He put the pizza in the bag down, dropped the bags on the floor where they were, picked up the baby, and took off for his car, and he drove to Phoebe Sumter. At Phoebe Sumter, he went in with JD. The nurse met him and put JD on a gurney, and then he followed them to a treatment room. Now, Alan testified. So there's this thing that Mr. Gamble keeps making a big deal out of. Says that this note in the nurse's record. He says this note says that the child is limp and pale, that father present at bedside states child fell around 5 minutes prior to arrival. Okay, and that note has an event time of 12:36. Okay, so Mr. Gamble wants you to interpret that as meaning that is what he told her at that moment when he went in. That he was standing at the child's bed when he told them that. And folks, there's other things in this note that we know it's not exactly accurate. It's close, but it's not exactly accurate. Okay, the note says that the child is in ER, and the front is taken to ER 16. From the front entrance of the ER, he is carried by his father, who is unresponsive. The father wasn't carrying the child anymore. He got met by a nurse after he came in the door, went to the desk, whatever, past the front desk, got met by a nurse and put him on a gurney, and that's what the other evidence was that you heard. He followed them to the treatment room, but Alan says that he didn't go in the treatment room. He wasn't bedside. He can't go in there when they're doing CPR and they're intubating the child and doing all those things. He remains outside the room, just outside the hall, in the hallway, and he does that. He does that because that's the only place that they'll let him go. So he's not bedside. Now, okay, by the time this note was written, he had been bedside. Okay, By the time this note is written, which wasn't actually entered until 8:04 p.m. By the time the note is written, he has been bedside. He was bedside when the child died. Dr. Bussman told you that. But he wasn't bedside when they were administering treatment, and he wasn't bedside giving a history. Okay, the note's written 8 hours later, and despite everyone's best efforts, it's very hard to separate all of the scurry of events that happened over the course of, just a little bit of time with regard to the treatment of this child. Also, okay, Mr. Gamble says he told them that 3 times. That note is in 3 times that he said that. He didn't tell anybody anything 3 times. Okay? The note is a nursing note on page 21 of 28 of the second batch of numbered pages. It's a nursing note. Okay? It's simply copied into the record because there's the nursing notes, there's a code blue report, there's physician notes, there's other reports, and cross-copied and copied on top of each other, which is why when you ask for your own medical record somewhere, you get 200 or 300 pages, they want to charge you for, and you realize ultimately there's only 20 pages of it that really matter, okay? And that's sort of the same thing here. The same records are copied over and over again because different people in different roles have to keep them. And then when we ask for all the records, we get them all packaged together. He didn't tell anybody anything 3 times at the hospital, and the hospital didn't write it down 3 times. It's one note that was written at 8 o'clock that night. Alan wants to talk to him. Alan said he was emotional, that he didn't want to talk to him there, and he didn't want him to keep standing there because he was upset. So Alan asked him to go out and walked outside, and Alan asked him to go outside, and he does. He told Alan.
As a gigantic welfare fraud is uncovered in the Somali American community in Minneapolis, we discuss mass migration and what did Ilhan Omar know and when did she know it? Plus, we'll get to the arrest of the January 6th pipe bomber as well as economy talk. First, today is your chance to Daily Wire Plus annual membership for 50% off. Don't miss our biggest deal of the year. Head over to dailywire.com/cyberweek to join or give a membership right now. Well, it seems that the Somali welfare fraud scandal is now breaking into full view, and it's hitting a lot of people who are elected officials. That includes, of course, the governor of Minnesota, Tim Walz, but apparently now it also includes possibly Ilhan Omar. So to understand why this matters so much, we have to understand this is all tied in a couple of major national issues. One, of course, is mass migration from third world countries. Is that something America should be pursuing? The second is a gigantic, unaccountable welfare state in which billions of dollars can simply go missing, and it takes years in order to uncover all of that. And those two stories are intertwined. Obviously, when it comes to the question of mass migration, the Trump administration has taken an incredibly strong position that mass migration, particularly from countries that do not cohere to American values, that mass migration should be significant.
According to Alan, he told Alan that Poague had told him that JD had fallen out of a chair. Poague got there, and she told Alan that JD had fallen out of the chair. She specified it was one of those round beanbag, or at least he interpreted it as a round beanbag style chair. And she says he was eating chips and drinking juice, and she heard him fall over out of the chair. Not that he just simply slumped down, but she heard him fall over and hit the floor. Okay, that's what she tells Alan, not what Williams tells Alan. I mean, it's the same thing Williams told him, but it's not what is not his words, it's her words. Okay, there's a reality to what we do when we go back and you look at records and you look at notes and you look at reports, okay, from 2 years ago, and you ask people, you say, okay, I need you to remember line by line word by word, second by second, minute by minute. Okay, I need you to tell me, what did you say and what did they say next? You know, and then we come into court and we have these, you know, these prior statements, and you know, we've got reams of interviews and records from hospitals and doctors and phones and everything else, and we say, you know, did you say that? Yeah, I said that. You know, I mean, and people, somebody know they said it. They know they said it at some point. You ask me, you know, if I said it to this person, and then you ask me, did you say it to that person? Well, 2 years later, it might be really easy to say that's what I told him too. You know, because it's kind of hard to delineate those things, and that's just the reality of the memory. Okay, that's the reality of the memory. Whether you're in the courtroom or, you know, you're sitting around, you know, on Christmas Eve with your family, and you start talking about something and say, you know, remember when so-and-so, and you realize that nobody there remembers it the same way you do. Okay, and you end up there, you know, like you have, you know, people just like, no, it wasn't. That wasn't on Christmas. That was on Thanksgiving. And it wasn't that year. It was the year before. And so I mean, the reality is, the only person who had information about what happened to this child was Trinity Poague. And she's the one who told Alan what Jay Williams testified to.
Today, no college football playoffs. We're talking Georgia politics. Burt Jones, what are you thinking on him?
He is not serious. He spent more time in office helping the Jones family business than helping my family. I don't want that as governor. I can't trust that. I like Attorney General Chris Carr. Look at the film. He's an ally of Brian Kemp.
Tough on crime, just like Trump. Chris Carr is going to eat whatever far left nut job the Dems pick.
My name is Scott Harris.
Just listen.
This is my wife, my son, and my one on the way.
Okay, what Jay Williams testified to, which is different than what Alan testified to, no doubt. Okay, what he says is that she was there and she told Alan in his presence, and that's where he heard the chair story from. In any event, ladies and gentlemen, the evidence as a whole shows you that it's Poague who promoting that story, not Alan. I'm sorry, not Jay Williams. I'm going to address it now. I'll skip it later. He says, you know, but ask him, did you tell Samantha that you knew, you know, did you tell her what happened? And he says, yeah, I told her what happened. I'm sure I told her what happened. And it's like, okay, well, did you tell her he fell out of the chair? Yeah, I told him he fell out of the chair, because that's what he told other people once he had heard it from her. But then he instead of getting the statement, the interview that that Fort had done with Jay Williams, okay, what Mr. does is instead of showing the interview and saying, look, you know, you want to, you know, refresh your memory about this, be sure that, you know, what you said, he doesn't do that. He's charging him with being able to have in his brain the knowledge of what he said in a 2 hour, I think it was, hour, 45-minute long interview on the day that his child died. Okay. So in the 8 hours following the time that Jay Williams found out that his baby was dead, he spends 4 of those 8 hours at the American Police Department sitting in waiting rooms or interview rooms. He spends most of that 8 hours sitting there. He spends 4 of those hours being actively questioned by Agent Ford. Okay, so you say, did you tell that without showing him the interview, without showing him the statement, without letting him, look back over and say, well, I don't know what let me see exactly what I said. That 2 hour interview. And Mr. Williams says, yeah, I told her he fell out of the chair, because that's what he'd been told, and that was the only information he had ever had about what happened to his child. he told Coroner Wright that Poague had told him that JD fell from the chair. But Poague also told Coroner Wright that JD fell out of the chair, that he was in a chair eating chips and then he was in distress and fell from the chair. So that Jay had been gone for 5 to 10 minutes at the time the fall occurred. That is the sum and substance of the evidence of the people who have testified in this trial, based on their memories, based on their reviews of records, etc. That is the sum and substance of what the direct evidence is about the events of that day. But it's not just direct evidence, ladies and gentlemen, that you make decisions on. Okay? The court is going to talk to you about circumstantial evidence. Okay? What circumstantial evidence is proof of facts or circumstances, actually by direct evidence, from which you can infer other facts that are reasonable and justified in light of your experience. Sort of like if the child gets his head bashed in and his liver busted 20, 30, 15, 5, 35, 33, whatever, minutes before the doctor sees him, and he's 18 months old and he's in a dorm room on the GSW campus and there's only one person in the room with him when it happens, well, those are two direct facts, okay? Those are not circumstantial, those are two direct facts. And the circumstantial evidence is when you take those two direct facts and you make the inference, which is under these circumstances, the only thing that reasonably could have happened was this. This is really important. Judge Sizemore is going to tell you that the law does not require more or greater certainty by you if you're returning a verdict based on circumstantial evidence rather than on direct evidence per se. Okay, that's because there is no rule that either circumstantial or direct evidence is stronger than the other. The comparative weight of the evidence is an issue for you to decide, just like it is if it's all circumstantial or it's all direct, if it's all testimony or it's all documents.
Planning to publish your book? You could reach 3 billion more readers. If you've written a book and you're thinking about publishing it, you have to watch this video. Hi, I'm Sarah from Spines, the fastest growing publishing platform in the United States. If you want to give your book the best shot at success, there are a few things you need to know. The world has opened up. Today's global book market spans multiple languages and formats, with international readers representing billions of potential customers. Smart authors are publishing in multiple languages and reaching readers all over the world. Most authors start with English, but there are 5 major languages and dozens of international distribution channels where your book can be available. At Spines, we expand your reach globally across 6 languages and versions, from softcovers to audiobooks in multiple markets. Using the most advanced translation technology and top-tier international professionals, all at an unbeatable price. Want to publish your book? Want to hear more details? Leave your info and we'll reach out with a phone call to share all of the information right away. Stay tuned.
Why I get triggered when someone gives me unsolicited advice. When I was younger, it came mainly from family, whether it was like a family member telling me where I should go to school, what career I should have. And as I got older, it appeared in a little more subtle ways, I think. For example, passive aggressiveness, peer pressure, and my response has always been to just put my guard up, like make the walls higher and just stop letting people in. It's definitely made me more of a private person and also less trusting of people. I remember the first therapist that I was matched up with, she gave me that same feeling that I got when someone just offered me unsolicited advice. What I really wanted out of therapy was someone to help me unpack that. Eventually, I did find someone who I felt like was the right fit, and that completely changed my outlook on therapy. She gave me the space to explore what was really going on and guided me toward clarity even when there wasn't a solution. With her help, I was able to understand why certain things triggered me, and I learned that my feelings are valid even when they don't make sense. I think therapy gives you a safe space with someone trained to help you work through whatever you're going through, and BetterHelp designed their therapist match commitment to make that possible. BetterHelp uses over a decade of matching expertise, clinical experience, and your preferences to match you with someone who makes sense for you. And if it's not working out, you can switch anytime at no extra cost. I think the right therapist can change everything. And with BetterHelp, they make it really easy to help you find someone who's fit.
It's all video or it's all audio. Ultimately, it's up to you to make the decision as to what the evidence means and what conclusions you can draw from it. So you take those things into account. You think about it this way. Say, okay, now we know some facts. We know some direct facts. So what are the conclusions that can be reached from the direct facts? Well, I'd suggest there's only two possibilities. Okay, one is that it's accidental trauma. That's a possibility. Or that it is inflicted trauma. Those are the only possibilities. But accidental trauma, ladies and gentlemen, is not a realistic explanation. It's not even close to a realistic explanation in this case. It's not a realistic explanation, well, for a whole bunch of reasons. Okay, it's not realistic because you would say, how many times you fall off the bed now? Now, I get this bruise and these bruises and these bruises. Okay, and they're not just bruises. Okay, I'm not picking them up and showing them to you again. Right? But you saw the medical examiner showed you. I mean, looking at the scalp on the skull on either side. Okay, there's brain bleeds here, and there's hematomas here and here and here, and then there's bruises here and here and here, and those things don't all come at one time. Those don't come from one fall. Maybe if you fall off the side of a mountain, and you roll 500 feet, bouncing every which way, you might bruise your whole body. Okay, they might occur in one event or at one time if you're in a car wreck, and there's one impact and you get impacted from every angle. But those kinds of injuries, it is not realistic to think that they be the result of accidental trauma when there is such a collection of them, and they all occurred within the same reason, within the same time frames. I think is what Dr. Clark's testimony was, that he thinks that those injuries, because they're consistent with each other, they're all new, they're all fresh injuries. Okay, the Dr. Oleg testified about the liver, for instance. She says that the liver, that you can tell that it's not an it's not a chronic condition. It's not something that's been on, but you do that from the lab results, because you look at the lab results and the liver enzymes are up. Okay, they're not 20 times higher than they're supposed to be, or 100 times higher. Okay, the liver enzymes in one case are like 200 plus times higher than they're supposed to be, and the other 400 plus times higher than they're supposed to be. Okay, and the reason the liver enzymes are so jacked is because it is an acute injury. It is something that has just happened within a short period of time. Now, none of those are specific about that injury or about the bruises. They're not as specific. They're not saying we can narrow it down to an hour, or within minutes or whatever, because there is a broader range in which those things could occur. But when they are there, when they aren't there, and then suddenly they are, and when they are there, they are in the presence, or they're associated with, or in addition to an injury that can be timed or dated, then you know that they almost certainly occurred all the same time. Accidental trauma, about falling off the bed. The only evidence in this trial of a fall from a bed, okay, all of it, the whole total of all the evidence. Nobody was told by Trinity Poague at hospital that fell off of a bed, that the baby fell off of a bed. Jay Williams wasn't told that he fell off of a bed. The police officers that she ran across at the hospital weren't told that she fell off the bed, that he fell off the bed. Dr. Bussman said he remembers, he said he didn't have a specific, he didn't know if there was a specific note, but he didn't remember for sure, if he said chair or what, but something about a fall. And he says, all I know is that when I asked her about it again a few minutes later, she completely changed her story. Okay, that's what Bussman told you. And that's not Bussman going back and looking at notes, okay, that are recorded by somebody else, etc. Okay, that's Bussman's memory. He says, I can't tell you what the stories were, but I tell you they changed significantly from the first time I talked to her, the second time I talked to her.
With the help of Xero accounting software, I've got the right information at my fingertips, so I can take my business anywhere. And I know where I'm heading next. Search Xero with an X.
With hundreds of sales every week, eat well for less at Whole Foods Market.
Okay, so the only evidence of a fall off of a bed is this. I'm sorry. I think I skipped something here. But anyway, so you saw the message earlier, and I may have it out of order. And if I do, I'll apologize for that and try to do better next time. But you saw the text. You heard it already, where she says that she told Jay to get on the bed, or she put the baby on the bed with Jay, and Jay let him roll off the bed. And she says he's okay, he's fine. Okay, so. Not only does she say he's fine, but her next text to Paris about what happened is this. Paris, this is when she's at the hospital. Paris says, did they say what happened or why they think that? She says, he hit his head at some point. I don't know. They won't give us much information. And Paris says, wait, didn't you say he fell off the bed last night? And her response is, I don't know. I was asleep. She doesn't know if he fell off the bed. That's what she tells Paris the next time the topic is raised. I don't know if he fell off the bed. I was asleep. The next thing she tells Paris is 3 hours later when they're talking about the skull fracture. Paris says, you texted me last night and told me he fell. That had to be it. And Trinity Poague's response is, but that was only off the air mattress. And the air mattress wasn't far from the ground. I can't text about it anymore. I don't know what's going to happen to me. So you have the one text, which is the only evidence of a fall from the bed. And in the next two text messages concerning that matter, Trinity Poague says, I don't know if he fell off a bed because I was asleep. Oh, and he just fell off of an air mattress, rolled off of an air mattress. Not only that, but the timestamps, and I think this testimony was in earlier, okay, the message about he fell off the bed was at 11:57 p.m. on Saturday night, okay? At 12:02 and 12:04, and I will tell you that I'm not 100% certain which one of those two videos that this screenshot comes from, but it's from one of those two, either at 12:02 or 12:04. Okay, either no, maybe more than 10 minutes after the child fell off the bed, but it is 5+ minutes since she sent the text saying he fell off the bed. Okay, that is the state of J.D. Angeles. Okay, and you saw the video in court. That's the screenshot, of course. And you look at it, ladies and gentlemen, and there is no big fresh bruise on the corner of his forehead. And he's sitting up, and he's drinking out of a sippy cup, and he was holding on to her hand and playing, as you saw in the video. Dr. Oleg, who's also not affiliated with the GBI, or anyone else, I mean, other than her own practice, Dr. Oleg told you that there is zero possibility that following this injury, the child could be doing these very things. Nature and extent of the injuries can't be explained by a fall from the bed. Too many injuries, too serious. They don't happen like that. And Mr. Gilman says, you know, he's like, Dr. Clark, you just can't trust Dr. Clark. Now he works for the GBI, you know, in the crime lab, which is true, which he is technically an employee of the GBI. He says, you can't trust Dr. Clark, you know, because Dr. Clark's going to say whatever they want to say, I guess, you know, it's when he's implying. It's not the case. Dr. Clark does autopsies, right? Sometimes the autopsies are, this is a natural death. This is a heart attack. Sometimes the autopsies are, this is an accidental death. You know, sometimes the autopsies are, you know, the death is unknown, it's unexplained. Okay? And in those, he doesn't get called to testify because nobody's being prosecuted for murder. Okay? The only time he gets called to testify for murder is when he made the finding that this evidence establishes that this was a murder. Okay? He doesn't get called to testify in a murder case because we decided that, oh, we got a murder case. Well, hell, what are we going to do? You know, let's call Dr. Clark. That's not how that works. He does the autopsy. He did the autopsy 3 days after the child died. Okay, issues a 6-page report, orders all kinds of stuff. Okay, comes into court, and yeah, you know, we're going to call him, right? We're going to call him to testify because his actual live in person with his hands and a scalpel findings were that this child was murdered. So of course they're going to call him. So Mr. Gamble says, you know, he says, Dr. Clark ain't as slick as he thought he was. He says, because I got him good now. I had this article. He got an article. We spend time on the article. Was that up here?
I don't know the deal. I think I gave it back. We couldn't send it to the jury.
You're the person with the gun, the person who would do anything to protect the one you love. But did you know that you could go to jail simply for doing the right thing to keep your family safe? Don't end up behind bars just because you didn't know what would happen after a self-defense incident. And I'm here to bring you this 100% free guide, the 6 things you didn't know would happen when the police arrive. Failing to understand 6 things could be the difference between freedom and a lifetime behind bars. And that's not what I would want for you, and I don't think that's what you would want either. Click the link right now to download your free guide that will teach you the 6 things you need to know to stay out of a jail cell and at home with your loved ones.
I can give you time.
It's all right. Okay. This is the thing about the article. Dr. Clark said, well, give me a minute, let me read it. We took a little recess. Okay, he read the article. Mr. Gamble comes back and he says, 4-year-old child in Chicago fell off of an adult bed, died 2 days later of an epidural hemorrhage. You know, 9-month-old in, you know, Portland, you know, fell off of a table, you know, suffered injury, was taken to the hospital and they did not have any findings, died 2 days later from brain trauma. And Dr. Clark says, yeah, he says, I'm not only familiar with Dr. Case or what her name is, he said, I'm familiar with her. He says, I'm familiar with the article. I'm familiar with it. He knows the other doctor too that's cited in there, Mabo or whatever his name was, who she cited. He says, yeah, I know these people. Okay, and I know this article, now that I've looked at it. He says, they're talking about epidural hemorrhages. Okay? An epidural hemorrhage is entirely different than a subdural or subarachnoid hemorrhage. And he explained on the stand, and I hope that you got it because, frankly, I probably didn't understand it well enough to try to repeat it to you. But basically, there's different layers between the, you know, from the skull to the top of the scalp, there are different layers. There's the glial layer, which is the fibrous tissue that's immediately attached to the skull. And then above that, there's the dura and the something and something else, okay? And you can have brain hemorrhages. You can have hematomas that resolve. They occur in different levels. You know, what level it occurs on, it's subgaleal or subarachnoid or subdural or whatever. The article was only about epidural hemorrhages. And he said we had a very small epidural hemorrhage in this case. The significant ones were subdural, subarachnoid, and subgaleal. Okay? Article has nothing to do with the facts or circumstances of this case. Furthermore, you go to the next section of the article, and it says that in almost all cases of subdural hemorrhages in a child, it is the result of abusive, which is exactly what it is the result of right now, in this case. How many times you fall off the bed? There's an occipital skull fracture, which is back here at the back of the head. It's a hard bone to get to. It's a hard bone to fracture because your shoulders absorb some of the blow if you fall backwards, and this part of your head absorbs some of the blow. And it's the thickest bone in the scalp, or in the skull, rather, the occipital. It's the thickest bone in the skull, he said. It's hard to crack, hard to bust, hard to split. It not only split, not only busted the full thickness, the fracture went all the way through the occipital bone, but continued into the parietal area. Okay? Now, Dr. Clark didn't call it a parietal fracture. He called it a separation of the lambdoidal suture. Okay, where the two pieces of the skull come together over here. Okay? And the reason he called that is because it was on the suture line. But the sutures really, they all develop at different times. When the sutures solidify, they come together and ossify the bone at different times in different children, different ages, and depending on where it is in the head. But it says this is bone. Okay, it was just on the lambdoidal line. Okay? The other doctor who did the X-ray, and this is what Jill Oleg testified to. She said it's an occipital and parietal fracture, okay? But in any event, the fracture goes from here all the way up here. There's bruises on the face side in front of the head. There's a lacerated liver and a lacerated adrenal gland. He didn't have any of these conditions or injuries when he got to Americas on Saturday night. So did he fall out of a chair, right? That's the, we went from falling off the bed to falling out of a chair. And I will tell you the same thing that I told you about the other fall, because it's just as applicable. The nature and extent of injury cannot be explained by a fall from a chair, particularly not a fall from this chair.
Stop taking meeting notes and let ClickUp AI Note Taker do it for you. It allows you to focus on your meetings, not your notes. It captures everything from action items to key decisions. And after every call, you get a clear summary. But where it really goes to the next level is that it's the only AI Note Taker that connects your meetings to the rest of your work. So stop stressing about taking notes and get the AI Note Taker that works for you. Get ClickUp AI Note Taker for your next meeting.
That chair, the bottom of the part would fall over. Okay, it's only 13 inches floor. Okay, so if you fell over that, there's only the only way to fall out of that chair is to fall forward. You can't fall backwards in it. y'all, you know, everybody here probably has seen one of these chairs or something like it before, I bet. And you know, kids probably have had one and all that. And it's a big fluffy, probably is kind of a beanbag. I mean, the cushion's beanbaggy, you know, it's not a whole beanbag chair. The cushion's beanbaggy. Okay, when you sit down in it, okay, the way it's shaped like a dish, you sit down and you basically sink into it. Okay, you couldn't turn the thing over backwards, you know, if your life depended on it, not from inside of it. Okay, and if you fell forward out of it, even if you were only 18 months old, you fell forward out of it and landed right square on your face and busted your forehead and did this and that and knocked out an eye and all kinds of things, you still wouldn't fracture the parietal bone, and you still wouldn't fracture the occipital bone. If the injuries cannot be explained by falls, the only realistic possibility is this child was a victim of inflicted trauma. There's just not another explanation. I mean, it's either accidental or it's inflicted. And if it's accidental, I mean, if it's not accidental, it has to be this. And if it has to be this, if it's this, then it has to be by who is the question. Okay, so Jay Williams, did Jay Williams inflict the trauma on this child? That's one hypothesis he offers. I was kind of stunned by this one. The other possibility he offers is, you know, JD himself, you know, he's active, climbing, growing, 18-month-old baby. You know, he might have done this himself. There's no telling what he climbed up on and fell off of. I'm serious. That's what he said. He said that to you. You don't believe that? Like this child, you know, man's coming. Yeah, if somebody had come out of that bathroom where they were, okay, and the child lay face down, you know, not breathing and unconscious and in respiratory arrest and with brain fluid seeping out of his mouth and his nose, if you've been laying like that face down, you know, on the side of the desk over here, and that was the only injury he had, you know, sure as heck, it could be accidental in that case. Yeah, I mean, it might be. But to think that the kid climbed out of, it's too dumb for me wasting more time. I'm running out of time for me to wasting more time talking about it. A kid did not climb on anything and fall off himself. So the only other option, the only other person is Trinity Poague. Now, I'll grant you that this case depends in a significant part on the credibility of Jay Williams. I mean, it does. You know, every case has witnesses. Some witnesses are more important than others. Some witnesses are essential to a case. Some witnesses, you know, they're kind of interchangeable. You can use this one or that one or whatever to prove whatever you're trying to prove. Jay Williams is an essential witness in this case. Okay, but I'm telling you, when you assess his credibility, you're charged about assessing credibility. Okay, like you consider their manner of testifying, their circumstances, how they would know the facts and circumstances, testify to their ability to observe, you know, whether it's corroborated by other testimony. Okay, his testimony was corroborated by clear, undisputed evidence. There is a video from GSW that Chief Lewis played for you, okay, that shows him walking out of the dormitory at 11:55, and shows him walking back in at 12:30, and shows him running out with a baby squeezed up against his body right here at 12:31. Okay, he wasn't there. Not only that, he's going to get a pizza. Well, you know, how about this? There's pizza, okay, right there on the end of the bed. You know, says he's going to Walmart. Well, there's Walmart bags, and there's stuff in the Walmart bags. And you reach in, you know, and you take it out, and you take a picture, you know, and I'm not, so, well, there's Walmart bags. There's a receipt that says these things in this Walmart bag were paid for at 12:14 p.m., okay? So if you left the dormitory at 11:55 and he's at Walmart walking out at 1214, I'd say he's moving pretty efficiently. He managed to get there into pick up items and get to the cash register in 19 minutes. But he did. Okay. Statements to Allen and Mathis. Okay.
I use PayPal to buy this ticket. I'm paying it off over time. No fees, no interest.
You know what else has no interest? Me.
You can pay your own way.
Excuse me, sir. The captain is you back in the cockpit.
Oh, yeah, sir.
What?
Elevate your everyday energy with the delicious taste of Spark. With classic flavors like strawberry and mandarin orange, bold fusions like cranberry peach orange and fruit punch, you'll never have flavor fatigue. Powered by B vitamins and 120 milligrams of caffeine, Spark is energy you can feel good about. It's a convenient and sugar-free way to get all the benefits you're looking for in an energy supplement. Use code FLAVOR to get a free sample pack for Spark and try all the best flavors to find your favorite.
To Mathis Wright, I said Mathis, I should have said Wright, I'm sorry. His statements to Lieutenant Allen and Reverend Wright were consistent not only with what he told them, they were consistent with what Poague told them. Okay? They're consistent with what she told them about fall by the chair, etc. Right? Big about the hospital records. Ladies and gentlemen, when you consider the credibility of this witness, I'm telling you, the hospital record does not disprove his testimony. It barely contradicts it. It barely, I mean, it's almost it's not a bump in the road. I mean, it's a pebble of sand that you walk over. The hospital record doesn't disprove his testimony. There's no one who comes in here and testifies and says, you know, this is what he told me. I wrote it down right word for word. I know this is what he told me. Okay? There's a hospital record that's assembled by a team of people who are working desperately to save the life of an 18-month-old child. Okay? And doesn't disprove anything but what he said. His GBI interviews do not impeach his trial testimony. Okay? Let me talk about this for a second. I talked about it briefly a while ago, but I want to go back to it for a moment. The GBI things, okay? What he Pardon me, I'm sorry. I have to take a sip of this water. What he told Samantha Ford was that he didn't know what happened to the child. Okay? Now, defense counsel didn't play the interviews for you, didn't refer him back to specific questions. He didn't refer her to specific questions to say, what questions did you ask him? Did you ask him what happened? He says, I don't know what happened. You know, she says, have you heard anything? Well, yeah, the only thing I've heard is what Trinity told me. You know, I mean, what Trinity told him isn't nearly as important in you know, for summarizing the interviews. Okay, it's not nearly as important in Jay Williams' summary as it is in Trinity's interview summaries. Okay, so you know, he says, you know, well, what do you do? You know, what he say? He said, well, he told me he didn't know. That's what he said. He said he didn't know. And it may very well be without questions being in front of you to know what questions were being asked and how they were being asked, that may have been the full and only absolutely correct answer. Moreover, his trial testimony was credible. The guy sits there, you know, he's not showing a lot of emotion. You know, it's been 2 years. You know, you come into a courtroom, there's a lot on the line. You know, you're seeking justice for your baby. Okay, there's a lot on the line. And there's y'all, okay? And y'all are a wonderful looking group of people, okay? But I'd be scared to death too if I was sitting over here, okay? And you know, and I'm asking questions, and Mr. Gamble's asking questions, and y'all all, you know, giving him a mean eye, you know, not giving really the mean eye, but you're all looking at him, okay? You're paying attention to him, okay? You're focused on him, and he knows you're focused on him, right? It's a tough position for somebody to be in, and you try to control your emotions because you don't want, I mean, anybody would. You try to control your emotions because you don't want to break down. You don't want to, you know, jello on the witness stand, okay? So you steel up, you know, you tighten up. You say, okay, I'm going to get through this, you know, and you sit there and you do it, you answer the questions cleanly, directly, okay? You answer them crisply, and that is the thing, if you think about, that you will recall from his testimony. That guy didn't evade a single thing. Okay? He's not trying to dodge anybody's question. He's not dodging. He's not ducking and dodging. He's not giving you this, you know, I don't know. I don't remember. That was a long time ago. You know, I mean, he's answering the questions the best of his ability based on what he remembers at the time he's sitting there. His demeanor was appropriate. His grief was palpable. He's at this point he's testified. Okay, he's in the courtroom when this happens, and Mr. Gamble says, he says, well, about this jacket that the baby supposedly threw up on. Supposedly threw up on. Okay. So I go back in the records, okay, in the recordings that we have, right? And I look and I say, are there any pictures that actually show the jacket where you don't, you know? Well, sure enough, you have it back there. You know, you look at it a little closer, and you see just how prominent that is. Okay, it is all down this side of the jacket. Okay, it's not only down this side of the jacket; it's inside the collar. Okay, I mean, it makes my stomach weak just to hear that. Okay, about, you know, I mean, listen, I love my children. I love them with all the world. Okay, but my was a nurse. Okay, when youngins started throwing up, you know, okay, I did everything. I changed diapers, I cooked meals, did all kinds of stuff. Okay, I'm like, Betsy, come here. You know, I couldn't stand it. Okay, it makes me puke for them to do it. This guy tucks that child against his shoulders, gets in a car, races to the hospital, and
today, no college football playoffs. We're talking Georgia politics. Burt Jones, what are you thinking on him?
He's not serious. He spent more time in office helping the Jones family business than helping my family. I don't want that as governor. I can't trust that guy. I like Attorney General Carr. Look at the film. He's an ally of Brian Kemp.
Tough on crime, just like Trump. Chris Carr is going to beat whatever far left nut job the pick.
I'm gonna get a
prototype. The hardest thing is to get started.
It's the ideas and the choice of which ones to flesh out that I think are very human discipline.
Have started to deal with computers in higher and higher levels of abstraction.
Just push a button.
Rapid prototyping allows you to identify what's important early on.
People then end up spending more time on the decisions of what they want to actually make.
While he's doing it, this kid is puking on, not on his clothes, not on the floor, not on the seat of the car, a baby bed somewhere. He's puking down his neck, down his shirt, inside his jacket. Okay? He doesn't let go. He doesn't let go. He doesn't stop holding him. He doesn't stop going to the hospital. He doesn't get to the hospital and say, here, somebody take this nasty young'un. Look, he's done yacked all over me. He carries him in until he puts him in the hands of somebody who might try to save his life. And we're going to mock him and say, supposedly someone threw up on his jacket. Come on. He was credible. He was credible as to what he testified to. And ultimately, ladies and gentlemen, there is this. He has no reason to harm his son. Now, Mr. Gamble says, you know what? They should have gone to Colquitt and talked to neighbors and friends and all this kind of stuff and asked about all that. And, you know, like they should have been investigating Jay Williams. Well, first of all, they make him sit through 4 hours of interviews, on the first day. Right, and they take his phone. Okay, they do a search for a search warrant. You know, they snatch his phone too, not one, two phones. They snatch 2 phones from him. Okay, and they're investigating. But when they're the dormitory people, okay, they're not interviewing people to say, tell me what you know bad about Trinity Poague. Okay, they're saying, tell me what you know about this baby being in the dorm last night. you know? And then from there, you know, it may go on to other questions, but so what do you know about the baby being in the dorm? Left. Gone. Okay. So that's what they're asking for. They're not trying to build a case or attack the character of this girl. That's not what they're doing. Okay. And there's no reason for them to go to Colquitt, because I tell you this, okay, you got an apartment in Colquitt, right? If this child had died in Colquitt, Georgia on Sunday, January 14th, 2024, okay, and Trinity Poague had been there in Colquitt with them when it happened, you think they're going to be coming up here talking to people that live on a dorm? No, they're going to be talking to people in the apartment next door, in the apartment across the street, you know, the people that he sees in the parking lot, the people that he sees at work. But those people don't have relevant information in this case, okay? They might have relevant information. If this child had died of malnutrition, okay, if he had died as a result of, you know, septic shock for some wound that didn't get treated, a negligence case or something like that, where you have a baby that just doesn't get taken care of, okay, where defenses all these kinds of things, you have that, then sure, you go interview the neighbors, etc. Okay, J.D. Ingles died because something or someone smashed him in the back of his head and cracked his skull open, and then smashed him again and split his liver. Okay, he didn't die because he had some sort of chronic abuse. He didn't die because he cried at night, you know, and the neighbors somewhere else didn't hear him. Okay? Nobody's aiming for Trinity Poague. Nobody's aiming for Trinity Poague. You know, hey, I'd rather have a different defendant, okay? You know, if it were me, right, if I got to choose who my defendant is, you know, I mean, I'd rather have somebody that looks mean and surly, you know, and is older, and somebody looks at him and says, oh, you know, he just looks terrible. That looks like a guy who would do this. You know, that's who I'd rather have as a defendant. And not an 18-year-old college student, or, you know, 19, 20, whatever she is. They're not after Trinity Poague. They're trying to determine how this baby died and who was responsible for it. Now,
it's been a little over an hour, so I'm going to let the jury have a brief recess. We're just going to make it a 10-minute recess, and then we'll let Mr. Lamb conclude his argument. Okay.
Thank you, Eric.
Just before 12:30.
Here's the career hack that got me promoted years ahead of schedule. I discovered that everyone hates taking meeting notes and setting them up. But if you do it well and you volunteer for it, you become indispensable. But here's the secret. You don't actually have to do the work. Otter does it for you automatically. It transcribes every meeting, creates perfect summaries, assigns action items, and positions you to take initiative on every project. While everyone is scrambling to remember what was discussed, you have detailed notes and can follow up immediately. You become the person who makes this happen. Executives notice that. You get invited to more meetings, and you get access to information and decision makers that others don't. Try Otter for free. It's literally the easiest career accelerator you'll ever use.
Monday.com is the best AI for work. Here's why. Let me show you some of the mind-blowing things thousands of companies are already doing with Monday.com's AI. If you're in marketing, sending bulk emails used to take hours. Now, AI summarizes, translates, personalizes, and sends them out in seconds. Sales teams, AI finds high-value deals and handles all the manual work after calls, so teams have more time to actually close deals. Recruiting? AI sifts through hundreds of CVs, pulling the best candidates instantly, making your hiring process 10 times more efficient. That's why people love using it. Monday.com, the best AI for work.
bringing a copy of the charge. Aggravated battery, not cruelty to child in the first degree. Y'all see that where I changed it. It only, I know that. That's why when we only addressed aggravated battery, that didn't sufficiently cover it. So I changed it. Okay, let's bring the jury back in.
Okay, we're ready. All right, Mr. Lamb, you can conclude your argument.
My energy bill dropped from $150 to $50 by doing this. My friends laughed at me when I spent $49 on a power saver device that could cut my energy bill in half. They thought I got scammed. But when I showed them my super low energy bill, they were blown away.
Check that out. This is our current energy bill. This is our last energy bill. And as you can see, over a 56% difference.
Hi guys, I just want to share a quick and simple technique that anyone can use to lower their energy consumption without changing their lifestyle. With this method, you can keep cooking, baking, gaming, running your dryer, wash at 90 degrees, and keep your heater running like you used to before. This method can essentially cut your energy bill in half by optimizing your home's energy grid. It lowers your energy bill by anywhere from 20% to 50% by bypassing the spikes in your home's current, which can lead to significant savings on your energy bills. It was discovered by Carl, an electrical engineer during last winter, when, like many of you, he was hit with ridiculously high electricity bills. His energy provider was charging him over $165 a month. It was insane, so he decided to do something about it. As an engineer, Carl knew the power grid we're all connected to isn't perfect. Millions of tiny energy spikes are constantly flowing into your home's grid. These spikes send excess energy into your devices, causing them to use more energy than they actually need. This is bad news for your appliances and your energy bill. Think of it like a bucket that's overflowing 24/7 without you even knowing. It's a massive waste, right? And of course, energy providers don't bother telling you about it or try to fix the problem. So that's exactly what he set out to do. Carl figured that if he could use Nikola Tesla's theory to streamline the current flowing into his home's grid, it would lower his energy consumption at the end of the month. So he built a prototype that uses the Tesla coil principle to stabilize electricity usage, cutting out all the spikes of energy you can use but still get charged for. He plugged it into an outlet in his house and let it sit there for a month. When he received his monthly energy bill, his jaw dropped. His bill went down from $165 to $62. It didn't just work, it was a massive difference. After Carl shared the results of his prototype on social media, investors lined up. He teamed up with a product engineer to bring this energy-saving device to the market. It's called EcoWatt, and it's this little plug-and-play device that can literally cut electricity bills in half. Here's how it works. Super simple. You just plug it into any empty power socket in your home, and it gets to work smoothing out your power grid. That's it. Just plug it in, and it takes care of the rest. Thousands of people are already using EcoWatt and saving a ton of money. Now he really wants as many people as possible to benefit from this. So he's running a special promo today where you can get EcoWatt at 50% off. Plus, he's throwing in a 30-day money-back guarantee because he knows how much your money matters. If it doesn't work the way you expect, just send it back. No questions asked. Just scan the QR code you see on the screen to visit his website, and you can grab your EcoWatt 50% off today.
There's a puff of smoke for Carson hosts of our playoff hopes are over.
Raja Caruth hangs on and wins it at Nashville.
Way to go, Raja. Hell yeah.
What ultimately makes me better is the people I have around me.
Connor just sucks. You're not on the green. There's green underneath my ball.
The summer of Connor Zillage continues.
What a day for Connor Zillage. We're housing broke in half. We're done. We're done.
You know, I think it's valid to be upset, but at the end of the day, nobody cares.
How many championships have you won?
6 or 7.
You know the answer.
I don't know the actual answer, but I mean, not counting quarter midgets, because I don't know how many I won then. But won 2 late model championships, 3 ARCA championships, 4 or 5 like open wheel midget championships. Never won a sprint car championship. I have a world championship in left car racing. I mean, probably 12 or so. At this point, I think it's a big enough deal where I just want to win a championship this level because it's such a high level. It just will set my whole life up. My whole life can be completely different in a few days.
Is that
What do you think? Do I look bugged out?
The regular season wrapped up. Playoff field is set. 25 weeks ago, teams had hopes. They had dreams, and some realized it.
Game where you think you have teammates. You may or may not. We will find out.
The NASCAR playoffs. If you know the sport, you know how decisive the topic can be. Look, fans take their winners on track seriously, no matter the circuit. To zip through it quickly, here's how these playoffs are designed. 3 races around with the winners and best performers automatically advancing until there are 4 drivers left to race for each of the sport's championships on the weekend. The thing no one can doubt is that the playoffs are a long haul, meant to grind you down, to test you physically, mentally, emotionally, which is how surprises happen. Surprises not a lot of people would have seen coming back in September when the whole show got going in Tennessee.
It's kind of crazy most of ours, not the playoffs. I feel like he ran good enough this year to be in the playoffs. I maybe be a little bit more conscious of putting myself in bad spots or where I don't push too much on pit road and don't try something new. It's kind of like a golfer, bad golfer, I feel like tries to make swing adjustments on the golf course. Everyone just does it on the range and then shows up to the racetrack or to the actual tee time and just plays his game. So in the playoffs, I pretty much just play my game. But it's not like we don't try here and then start trying in the playoffs. So I don't look at it like, oh, we're gonna start to suit up for the playoff.
Bristol Motor Speedway. Tonight, it's the playoff opener for the NASCAR Xfinity Series.
Going in the playoffs, there's a lot of pressure, but I think a really good philosophy to have is just don't beat yourself. But dude, freaking anything in the playoffs.
And we're going to have some fun at this iconic short track.
Bristol, one of my favorite racetracks, probably my favorite short track, and this is my favorite the atmosphere of the Bristol night race. And I feel really confident about it.
Awesome. Best of luck to you here tonight.
I love you.
Do your thing.
Let's do it. Execute. Okay. 300. He knew Bristol was going to be difficult, but if you don't have the work ethic and a strong mindset and know how to push through, this sport will chew you up, spit you out in a heartbeat.
The playoffs underway in the NASCAR Xfinity Series. You can run, but you can't hide at Bristol.
Nasty pack of cars in the back, and they are rumbling 3 wide.
Spin in turn 2, 17:48.
over to Tyler and tell him to stop being a idiot. All there. Yeah, okay. We have 7 laps to go until the end of stage 1. Pit road is going to open right now, so let's see if we have any early takers. This could be an opportunity to jump some track position. If we can get stage points, if we can restart 5th and get stage points, we'll stay out. If not, pit. Do the opposite. Stay out. Jesse Love stayed on track. Everyone else pitted, so 2 drivers stay out. That's what we got here, buddy. Okay, so just drive us off. It's going to be a short run here.
Just 2 laps to go in stage 1. Up front, Harrison Burke is inside Jesse Love. They pit.
Jesse Love takes the lead. Clear, all clear. 1 more. Jesse Love way up the racetrack in turn 1. He got loose. Hit that bottom. 3 top, 3 top, 3 top. He lost 5 spots on the racetrack. Justin Allgaier will win stage number 1. What just happened? I don't know, man. I mean, nothing. Oh my God, I'm going to flip out. Double extra flat? That's what I thought happened. I mean, it just looked like you went down in there, shook the rear tires loose. That's all it looked like. I don't know.
Every competitor knows the feeling. Those days when it feels everything's going wrong.
Stay in the game here. All right, let's just try a little bit harder.
For one of our playoff contenders, Jesse Love, the 2 car.
The right side tires on it.
For Jesse Love and his team, the playoff opener at Bristol was one of those days.
Somebody explain to me what just happened. Jesse Love with a flat tire late in the race dropped to 25th. Head up, team. Head up. We're going to fight to the end here. We had a bad day.
You're still in the fight. But yeah, days like today are like getting kicked in the gut.
Tonight was pretty bad. Clearly nothing went our way. At one of our best tracks, I feel like, as a team with a car. I have no idea what the f happened down there. I promise you, I did not miss my mark. I did not overdrive the entry. I went down in there and blew a left rear that never blew. It was the weirdest thing in my life. I've never felt that in my life. This weekend, we didn't do a good job, obviously. I don't think it's like us being dumb or putting ourselves in a bad spot. I think that's what happens when you run back there with the people that you should be running with. So, like, if I were to get struck by a meteor running 20th, I would blame it running 20th, not what happened running 20th, right? So, yeah, that stuff typically doesn't happen when you're up front. So, no idea why. Today we were so bad, but who knows?
We're just doing eggs today. I do eat eggs a lot. It's like kind of a good cornerstone for my breakfast, but this is light. I do the 4 eggs and a pancake or 2 and turkey sausage, but that's a full like post-workout meal. I actually feel like I'm a pretty good chef. I'm not perfect, but nobody's perfect. Most important thing is to stay in the game and not take ourselves out of it. So even if we're not the fastest, just execute a clean day, pit road, pit stops. I would say more of a focus on just having a clean race more than anything. So I think also there's a certain level of just like letting it be because you've done the prep and stuff during the week. So not to overkill it this morning. Breakfast done. Do something great today.
It's an absolutely gorgeous day here at the Magic Mile.
Good luck today. Win it all.
Do you feel like you're on offense or defense for this race?
The best defense is good offense, I would say.
We only have 45 minutes and want to make sure we get you to the end of this thing, which is pretty great. So in the interest of time, sprint the next few races, making sure you get the main idea. The playoffs are unpredictable, and the standings follow suit.
Every point matters, every position. Fight hard all day. Trouble in turn number 1. We got 2 trucks around. Get it out of me right there.
Rajah gets by just in the nick of time.
How well are you breathing right now?
Well, it's not good yet. I couldn't promise you that.
I think for me, the nerve-wracking part is the point situation.
Checkered flag here in New Hampshire Speedway. Nice, Raj. We're in for the next round.
They're oval.
Only the top 10 get stage points. These playoff drivers need those points.
Motto, the goal, whatever you want to call it, is to live another day.
Jesse Love came in 5 points above the cut.
Focus hard here. Doing great.
Being able to win this stage is a massive statement by this 2 team. Trophy number 10 for Connor Zilic comes at the Charlotte Roval.
It's a foregone conclusion at this point that Connor Zilic wins.
Stay on that pain, brother. Stay on that pain.
Runs a really tight line. Doesn't give Jesse Love a lot of room.
I did a lot of things really, really good tonight. I also did a lot of things really, really bad tonight.
Doing in the Talladega because this is the most amount of drama I can remember.
You got the plan, we got the man, won't be Talladega.
This is it's going to get the stage win.
Raja Carew, the winner of stage number 1.
That was close.
It's going to come down to just what guys can survive.
Patience, big picture here.
To watch Jesse Love do what he's doing right now is flat impressive. 1 race to go. Jesse Love is really good on points at plus 40. Zilic and Allgaier have clinched a spot in the championship 4. Who joins him? Find out at Martinsville.
If you've been wondering what Carson's been up to since being eliminated from the playoffs, well, so were we.
It's over for you, pal.
And we found him here in Florida, racing in his own kind of playoffs, but not exactly NASCAR grade.
What's different about this car than
Bro, look at the thing.
It has real headlights. It has a CD player. We don't have CD players in Cup car.
What you're looking at is called 2.4 Hours of Le Mullins, a play on the world-famous Le Mans race, but with an American twist.
Got this.
Featuring some of the biggest names in the YouTube racing world, and hosted by Cletus McFarland.
You guys ready for some racing?
You know, Carson is just the coolest guy in Cup right now. Dude, it's so fun. I'm driving in the middle of nowhere, Florida, in front of an awesome crowd. I shift like in this thing. Just slinging it, running into people, bonsaiing a little bit.
Don't be afraid to use your nitrous.
Using nitrous when you need to. Things like this is super fun. And thank God I raced for Spire Motorsports to allow me to do this. And recognize that I do race better when I'm having fun. There's something I could take away from this to help me in the Cup car. I don't know what the hell it is, but there's something that can help.
Okay, back to NASCAR. The short track at Martinsville hosts the final race before the championship in Phoenix. And while Raja and Jesse headed into it in good shape to qualify, it was just impossible to predict what the racing gods might have in store for them.
Focus on just having a clean race tonight, getting points, running up front. I can't put the bed here today and expect everything to be all right.
How do you manage it, Raja, with 14 points to the good entering this race?
I'm in a good spot right now, so let's do our job. I mean, what's there to stress about? Only a certain amount of things are in my control, so I'd focus on doing those things right, and I'm sure everything will work out the way it's supposed to.
All right.
Raja Carew, Tyler Ankrum, they have a lot of points, but that can slip away really quickly.
Playoff elimination night for the NASCAR Craftsman Truck Series.
Minimize mistakes on restarts, pit entry line, hit the juice box, just a friendly reminder on a few of them things, Thank you. We'll have a good time tonight and see y'all in a little bit. Thank you.
Green flag is up, we're underway.
Straddling 2 here to 9's on your door, on your quarter. Nice rhythm now, nice rhythm. Raja Caruth diving now to the inside of Tyler Ankrum.
Ankrum outside, Caruth to the bottom for 6.
No unusual chassis to start. Need to wait for the right rear to come in a bit, but that last lap, it was pretty good. 10-4, 10-4. Around goes Andres Perez to Lara. Damn, it's like every time I get close, caution comes out.
Green in the air. Oh, Riggs doesn't come up to speed.
Jam it. He coming.
There's a lot of damaged trucks on that front to rear contact among everybody that restarted on the bottom.
Happened on the restart. 34 misstep.
Had every appearance to it of being a misship. Raja Caruth get a lot of damage.
Jamie, this is who I'm concerned about right here. Raja Caruth, a lot of damage, and he is fading fast.
How'd you let the one on you? Concentrate, man. Concentrate.
got inside of me. I'm driving as best I can while I'm filing the damage. I'm adjusted to it. It happened.
Your front's all knocked in. Lucky we're not leaking water. Regroup. Take care of business, man.
Green and white checkered flag goes in the air. Stage number 1 is complete.
All right, man. Deep breath. I just took one.
Okay. This tight fitting because of the damage. That's what I'm struggling with here.
Do the best you can here, man. I know you're trying really hard. You're doing a great job. We'll get some on the nose, get rid of the parachute.
10-4. I'll just survive until then.
Green flag here at Martinsville Speedway.
Raj on the inside.
Very aggressive 3-wide move underneath Cape Honeycutt.
Be aggressive, smart. Take no prisoners. 52 tucked in behind. Gonna bump you.
Great battle right here for the 7th position. A little bit of bumper tag through the middle of the corner. That's normal for Martinsville.
Don't take nothing from a teammate. Is there a gap behind him? For all your work, man. There's no gap behind him. Do your best. I know you're trying, man.
We're going back to where the bench is. Rajah Caruth and Keaton Honeycutt.
In there. Inside.
Contact right to Rajah Caruth. Caden Honeycutt.
Trouble turn 1. Rajah Caruth goes for a spin. He was running side by side with Caden Honeycutt.
This is huge for Rajah, for the team, and for all the playoff bubble standings.
Cut my left rear.
Rajah was 8th at the time, trying to race his way into the championship 4.
Caden Honeycutt maybe a little bit up on the curb right there. They get side by side, like the exhaust pipe on Caden Honeycutt's truck was right where Rajah Caruth's left rear tire was. And as soon as those make contact, it cuts that tire down instantly.
Yeah, we're done.
Is there anything I did wrong there, Eddie? You just cut my tire.
He's side-by-side hard racer. He got into his quarter.
Rajah Caruth going back to the garage with a broken heart and a very wrecked race truck. The first of our playoff drivers out.
I was feeling really good about our chances. Just racing. I know it wasn't on purpose. It happens, obviously. I'd racing here. It's just, it was me. So it's yeah, heartbreaker for sure. We were in a really good spot. But it is what it is. So keep on pushing, and the sun will still come tomorrow. It sucks now, but yeah, it's part of it.
His championship hopes is over.
Yeah, it's tough. I try to be really in the moment, you know, and at this moment, it's definitely a bummer. It shows it's never promised, you know. Maybe it wasn't meant to be this year. Maybe it's a lesson. That's what it is.
Great crowd here tonight at the Martinsville Speedway, getting set to go for the NASCAR Xfinity Series. Jesse Love, currently 3rd in the championship standings, 40 points to the good, looking to run for a championship next week in Phoenix.
We're not in a great spot. Like, we start 21st, and obviously there's a lot of pressure there. If everything works against us, have a good day, then yeah, we don't go to Phoenix, right?
But you said plenty of time, got 250 miles to get there.
Try to keep that blood pressure down, all right? Let me see, I got it.
Got this.
In the fight, know your surroundings.
You got this.
Okay.
Time to go racing in Martinsville with 2 championship spots on the line.
You got this, buddy. You got this. Copy.
Green flag goes in the air, and the NASCAR Xfinity Series is racing in Martinsville.
Easy.
Last thing that wants is to sustain some pivot, having to be very careful at this early junction.
Slow the center down. Get points sooner, bro. 44. Easy, stay low.
Contact.
I can't wrap the bottom at all.
These guys are being aggressive. They're bumpers off. The longer we go, tempers are going to get shorter and shorter out there. Trouble, one car goes for a spin, slide up the racetrack.
10, 4, 3, 2, 1. 4 tires here. 4 tires.
For a couple of penalties under this round of pit stops, including Jesse Love, too fast on the pit lane.
What happened? We got a penalty, section 12, speeding.
Okay, just let me know when I need to run out. I ran what I was told to run out of the pit stall.
All right, that's our final and only mistake of the night here. Okay, let's clean it up here. We got this.
Here we go, second stage.
It's like easy, good, all good, all good.
It can get really congested. That's when the issues occur here.
I got to figure out how to get you out of this harness mess, man. Be smart here.
Coming in turn number 2, Jim. Turned around in a heavy pack of racing traffic.
We're getting killed off the corner all the way down the straightaway.
I am so slow at the 5/8 mark. So I just need clarity on what I need to do.
Well, the best thing right now is to tell me what the car is doing, and then I can fix it.
I need the front end to turn better.
Pit lane is open.
3, 2, 1. Put on the brake wheel here.
Jesse Love in that number 1 pit stall getting his service.
Go all the way. Do not speed. Do not speed. Do not speed.
Penalty on pit road, and for the second time tonight, the penalty is a playoff driver, and it's Jesse Love. They got bumped for equipment interference.
All right, we got another penalty for equipment interference. What does that mean?
You see the tire in the back, runs into Mike Snyder's tire there. Oh, they're saying the tire left the box.
We're gonna be fine here. We're not gonna let this get us down here. We've got to clean it up, everybody. We got to clean it up here.
Back over the green flag. 23 laps to go in stage number 2.
All good. Stay in line.
Jesse Love had to start at the back of the field because of that equipment interference penalty.
With Koga here on the inside, he's going to hit the curb and go up the racetrack, almost into Jesse Love. Jesse's thinking, what's going on here?
Wow. They came with a 3-point cushion. They've been to pit road twice. They've made 2 mistakes on pit road.
One more, easy, stay low. Easy.
The car getting into the wall. It all happens right in front of the playoff driver, Jesse Love. They're having themselves a bit of a rough night. Not what you need to do when you're trying to make it to the championship. Green, white flag in our second stage of the night.
We're P30 right now. We're not going anywhere. I mean, if we don't get this car better than it is right here, we hurt here.
I would swing big.
Final stage at Martinsville.
Jesse Love has gone backwards since the restart.
Fighting hard, buddy. Fighting hard. I know you are.
It's getting to the point where they're getting a little bit nervous in their pit box. At the moment, he's only +9.
A few minutes later, though, the news gets even worse, as Carson Quapple leapfrogs him in the real-time playoff standings to gain a 3-point edge, leaving Jesse and the number 2 team on the cut line.
How do the points look right now?
Every point matters, brother. Every point matters here.
30 laps to go. The Love team's nightmare scenario is for a playoff car below the cut line in the race, which would bump him out of the championship.
Think about the nerves right here, knowing what's in front of him, the opportunity ahead of him.
Brandon Jones able to take the 3rd spot away.
20 wins, we're going to be okay.
This is where you got to be aggressive. These guys are in must wins.
So much pressure on these drivers to perform.
Championships are on the line. A lot of frustration. All they had to do was just have a clean night, and it's been anything but that.
White flag. All good.
Racing for a championship berth.
Everybody is just going for all they can right now.
Checkered flag is out.
Talk to me.
Yeah, we're good. What a night, boys.
Jesse Love will advance, joining Connor Zillage in the Championship 4 next Saturday at the Phoenix Raceway.
All I can say is good job fighting all night, guys. Proud of you. We're going to forget about it. Let's go win a championship.
Go run for a championship. What? We'll go run for a championship. Let's go run for a championship.
Jesse Love's leaning up against the wheel-in car, and the good news is you qualified for the race. But Jesse, I can tell by your body language, that's certainly not what you guys want. So what's your emotion, what's your thought right now?
Yeah, it's got to get, focus on Phoenix.
Sorry. Yeah, I don't know. The main thing for him to take away is just perseverance. He just didn't give up. Did not give up. Good job. But to come out of here and to have a shot at the championship, that'll provide for a lot of good dreams for the rest of the week.
Nice job of surviving, man.
Yeah, blue collar. Who's going to win the championship?
Probably you. Sorry.
I'm racing the 88 car for a championship. I mean, there's definitely nobody I'd rather beat for the championship than Connor. But I don't look at it any different if it was him or the 7 or the 1, whoever I'm racing, right? Obviously, I'd rather be racing somebody that was slower, right? But the 88 and 7 are both going to be really good. Yeah, we'll see.
I was born in San Francisco.
Thank you. Good luck Saturday night. Could you sign this picture, please?
Man, I've been racing against all these guys all year, so I don't think that the execution needed to win the championship changes as at all. It's still the same people I'm racing against all year.
Bringing back sweet sunny day.
Me and Connor went to some breakfast place, and my order number was number 2. So I was like, "Oh, you're screwed, bro." Subconsciously, I definitely have that jealousy of watching Connor win every week, and it does suck. But I want to be around greatness. Like, Connor is a phenomenal race car driver, great person, great friend. Like, that's something that I do want to be around.
Every week we ask you about your relationship with Connor, and I mean, where do you find that sweet spot in your relationship?
I think just being able to compartmentalize things, right?
I was going to ask you if part of this amazing mental mindset that you're in right now, because you and Connor are going through this together, and you have a trust with each other that is just magical.
I feel like I've just found myself in a really good spot mentally this week, and subconsciously, Connor's helped with that. Maybe he hasn't. I'm not really sure, but I'm racing against the enemy all week.
Jesse's probably one of the most competitive people I know. I feel like that's why we get along so well and why we're able to kind of push each other. When we put our helmet on, we aren't Jesse and Connor anymore. You have to understand how to separate the two, which is really tough.
I don't really explain this a lot to people, but how I go about these moments, I try to manifest the result, right? And now I'm just trying to catch up to it in time. So in my mind, I have over 1 tomorrow night. I just have to catch up to that in time. Because of that, when you keep adding the pressure on with life can be completely changed in a few hours and all the stuff that's at stake and things like that, I think mine, because it's already done, it's just cool. It's even better, right? Not scared of failure. I already have my speech written out for the most part. I've rehearsed it. I've kind of gone through the weekend, how I imagined it. I wanted to play out in my head, in the driver's seat, in my interviews, things like that. And yeah, there's definitely been times where I've been on the racetrack and not been present in just the moment and been present on just feeling the tire and having the right mindset because I've been focused on other things. To win tomorrow, I have to do it without thinking about anything. My only value is to be just drive hard.
The stage doesn't get any bigger. The season is on the line. 4 drivers competing, 1 champion crown. Welcome to Phoenix Raceway for the Xfinity Series Championship.
What an interesting mix it is of the 4 drivers. The driver that has stolen the show all season long, no doubt, has been Connor Zilic. He's gone to victory lane 10 times. You've got the reigning series champion in Justin Allgaier, and you got another newbie in Carson Quapple, who's winless so far this year. You've got Jesse Love, who won his opening race at Daytona International Speedway. He's earned his right to race for a title today.
Jesse just wants it. I mean, there's a lot of kids that say they want it and they think they want it, but there's a difference in saying you want it and really wanting it. This is all he knows. I mean, he left home at 14, 15 years old, moved away from his family, started his own life at a pretty young age, had to figure it out on his own. It takes a lot to do this for a living.
Enjoy every moment today.
Have a good one out there, man.
Good luck. Let's go get it. Let's go, baby.
You got this.
I'm ready to make them all look stupid.
These are the moments when it all becomes real, and you know it's all getting ready to happen.
Bring one of those stogies after I win.
We'll all be smoking cigars.
That's right. Thank you, RC, for everything.
No, thank you.
Go get some more.
Just be Jesse Love. All you got to do.
Yes, sir.
I love you, son.
I love you, son.
It's time to rise to the occasion, and I don't want nobody else in my car besides you.
Love you.
Put your nuts on the dash and let's do it.
Okay, yes, sir.
The waiting is over. Let's crown the champion of the Xfinity Series.
Drivers, start your engines! The pressure on all these guys tonight, biggest race of their life.
All right, buddy. There ain't nothing to do but to do it. Or we're in this position for a reason. We're going to execute all night, or we're going to bring home a trophy tonight, okay? There is no other option.
Yes, sir.
Green flag goes in the air. It's go time in Phoenix.
Nose to nose into turn number one. Everybody finding their manners back through the top 10.
Allgaier trying to get to the inside of Jeff Love. Goes to Chevrolet Camaro, door to door.
Right now.
Ooh, it looks like the two cars struggling a little bit.
Biggest thing that I see is drive off. Need to wrap longer, exit lower.
Eric Almirola to the inside of the Jesse Love machine. Jesse drifts a little wide.
19 mode contact.
That's tight. Love slides up the racetrack. The car swirly on the corner.
For Love, managing your emotions because he maybe had one of the best cars in practice, but it's not translating to the start of the race right here. You see he's faded a little bit.
Are we just wrecking? What? Are we just wrecking sideways? Yeah, I mean, I'm playing center and I have to drive.
Jesse Love has fallen all the way back to the 10th position.
The car has gone really loose.
He is dancing on the edge of the blade, just dirt tracking his way.
Come on, man, just keep fighting here. We're going to get you fixed up. Try to put more front brake in that. You need to here. Stay focused.
Green and white checkered flag to wrap stage one.
I think I need more drive. That was my gut reaction. The right rear just had grip.
All right, 4 tires here. Track bar down 2. Got the sign here. Got the sign. Leave it hard. 2, 1. Put on the wheel straight here.
Jesse Love backslid to 12th, complaining that the run went from really free to really tight and was over-rotating the center. The call is for 4 tires for Danny Hoffman and 2 down on the track bar.
All the way, 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 all the way. All right, buddy, you got this here. Let's do it.
Green flag goes back in the air. Connor Zilich will match him stride for stride as they all head for the dog leg. Zilich down low, top playoff guy. Right behind him, Justin Allgaier, and there goes the 88 on point.
Connor Zilich, he'll take the lead.
Jesse, try a bigger arc to 3. You can have a lower leader exit. Little tight. Remember what we talked about, buddy. You got to win on entry. Win on entry. See if a lower exit has more drive on exit of 4. Stay the game here for me. You're doing fine here.
Here comes Jesse Love.
I think the good news for Jesse Love is that he's moving forward.
That was a really good lap, dude. Keep doing that.
Jesse Love gets a nice run out of turn number 2.
Trying to make it happen late in the stage. Now working Nick Sanchez for 6 with 4 to go, stage 2.
4 stage, bro. Back here on his rear. Fine.
You can tell by the time for patience has elapsed. It's time to get it done right now, and Jesse Love is going to the whip.
Gates on it. Good one, dude. Really good.
Jesse Love's moving.
Love has made his way to 5th. Green and white checkered flag. Championship 4 delivery is get set for the final run of the race.
I felt like my drive off was more than good there. That run. All right, half up track bar. Half up track.
Coming to pit road, the 2 cars going to have to execute perfect pit stop.
4, 3, 2, 1. Put on the brake, wheel straight here.
Jesse Love drove up to 5th in stage number 2. They're going to be track bar adjustment, 4 tires and fuel.
Jesse Love felt like as the track frees up, they're going to be able to contend with the front runner.
All the way. Do not speed, do not speed.
Race off pit road. How about the 2?
Wow.
Knocking it out. +4. That wins the battle off.
You guys are unreal.
Let's go. Hey, boys. That's how you do it right there.
It was an amazing pit stop. Picked up some confidence, picked up some speed. So, feeling better.
Jesse Love in control, takes the outside lane. Final stage 2025 underway at Phoenix.
Really good corner there. Really good corner. Only place he's beaten you is entry to 1.
2 have busted loose from the rest of the trying to get this a 2-man dash for the championship.
Yep, there it is, brother. Keep doing that here. Keep him in your sight. Take care of your stuff.
Battle for the race lead.
Jesse Love is all over the back bumper of Justin Allgaier.
You're doing great here. Make you push.
Jesse Love glued to the back bumper.
Jesse Love trying to move Allgaier out of the way. Now he falls about a car length behind.
You gotta hit your mark, brother. You got a good.
Double turn number 3, around into the outside wall. Hard goes Ryan C.
That'll put it on the caution flag.
I know I have more drive than he does. I can see it. He's got a little bit more turn.
Said that you can see by the not only his but the things he did, his actions, the way he came out of the door and talking to that child, and all that, and to my knowledge, nobody had ever asked. I certainly had never asked until it came up in this trial, and he testified to it. I said, "You were talking about your jacket, and they're talking about why we didn't collect the jacket to test for vomit." And he says, "Well, I guess you still could." And so that's what I put him back up on the stand later, if you'll recall. And I said, "So do you have the jacket?" And he says, "Yeah, I've got it." But where is it? It's home. He says, I said, "What's it?" He said, I never washed it. Shirt either. They're there. I said, "Well, why haven't you washed it after 2 years?" And he said, "Because it's the last thing I have left from my baby." Okay, that guy is not going to beat this youngin to death. Okay, Gamble's giving you a 5-minute window in which, I'm sorry, that hand I heard on the table saw, and it looks funny to me when I hold it up. He's not going to give you, he's giving you a 5-minute window, okay, where he says it had to happen. That Jay Williams could have done this 5 minutes while she's in the shower. Never mind, they're still in the same damn dorm room, okay? But he says he could happen in this 5 minutes. That she's in the shower and he's out there with the baby. Okay, there is nothing about Jay Williams that would lead you to believe or support the conclusion that he would have done this to his child. Who had a motive? If you could have a motive, right? Like these cases are hard. Okay. I think Mr. Gamble may have misinterpreted me when I said that this is easy. I'm talking about, that element of the decision-making process becomes easy when it gets to this kind of a case. Okay, but these cases are hard because these are the cases where every jury is going to give every defendant the absolute most presumption of innocence and the most benefit of reasonable doubt ever, because in your heart of hearts, like every other living, breathing human being, okay, you don't want to believe that somebody could do something so terrible to somebody so innocent. Okay, nobody wants to believe it, right? So if you get past that, ladies and gentlemen, in your deliberations, you get to the point where, you know what, I believe it, okay, you've passed reasonable doubt stage, okay, because you're giving her anybody else, you're giving anybody in this position because you don't want to believe it. Nobody wants to believe it. So how do you make yourself believe it? How do you accept that Trinity Poague do such a thing? Okay, yeah. So she have a motive. She resented and ultimately despised that little boy. Okay, now you know this from her statements. Her text messages said we're starting back in August of 2023.
As a gigantic welfare fraud is uncovered in the Somali American community in Minneapolis, we discuss mass migration and what did Ilhan Omar know and when.
All right, starting in August of 2023. These are in evidence. Remember, they started these exhibits. These are the text messages that came from Paris Permort's phone. Between her and Trinity Poague. He started the back and moved forward because because that's the way they're stacked up here. And she says, "I'm going to sleep in your room. I can't do JD crying that much. Hopefully he's in a better mood in the morning." Okay. Then she's talking about getting in the shower and she puts him in the washer in the shower and it gets water spraying on his face and he apparently didn't like it and was acting. reacting to it or whatever. And she says, I'm trying to take a shower and I had to bathe him. And I just sat him down and let him cry because I'm not about to baby him. Okay? I'm not going to baby a baby. When she was talking about Jay Williams, I'd say, I wouldn't baby him either. Right? Grown person. She's talking about a little kid. She's talking about a kid that stands that tall. Okay? That's unsteady on his feet still. And she said, I'm not going to baby him. The witnesses that came and took the witness stand that were called by the defense said, oh, yeah, she didn't like that young man. She didn't like him. She didn't like him. And not only that, he didn't like her. He didn't like her. She sends more messages. In August 17th of 2023, she says, why do I feel anger towards JD? When we were in the bed and JD kept touching Jay's face, I almost cried. Because the kid is being affectionate towards his daddy, it's upsetting her. And Paris got nervous. She says, what do you mean? I feel anger towards JD? She goes, I don't know, not jealousy, but I want to love him. But instead of loving, I just feel like angry, like I want to punch him. Laugh my ass off. Oh my God, that sounds so bad, doesn't it? Yeah, it does. It does. It does sound that bad. And then the explanation comes in the next two messages. Ever since he's gotten here, Jay has not touched me. He's currently on the floor. Okay? The baby is interfering with her relationship with Jay Williams. Later, 5 days later in August, she sent a message to him, to Jay Williams, and she said, I told you from the beginning I would always try to love JD the same as mine, but since me and you have gotten serious, every time I see him, I just get angry at the world and just have a gut feeling of anger. I don't know what it is. But just seeing him makes her angry. She sends a message and I'm gonna come back to it. Let's go to January. The day before, the night before, he was murdered. Says, what do y'all know about tonight? That's Paris's text. And the response is, no clue. I guess I'll probably sleep on the air mattress in the sink area. I can't do being around JD anymore. He hates me and I hate him. And if you examine her conduct towards the child, ladies and gentlemen, you will see that, in fact, that is true. There's an old saying that says, when people tell you who they are, believe them. November of 2023, she told Jay Williams that he had hit his face, had hit his eye, that he bruised his eye or cut his eye, injured his eye, that she was cleaning up near the cabinet in the bathroom, and she didn't realize he was behind her. She opened the door or the drawer. I don't remember which one he said, but she opened it up and she hit him in the eye, hit him in the face. She said, I felt so bad. I felt so bad. Okay. Where's JD when he gets the blow to the face? Okay. With Trinity Poague and nobody else. He ain't with his daddy. He's with Trinity Poague. In December of 2023, she sends a message that says, Jay, this is December 17th. She says, I don't know if I can do this anymore. This weekend was a struggle for me, and I don't know what to do. I love you so much, but letting JD hit the wall and see the damage it did really hurt me. Okay? What in the world is that about? Hitting the wall. Asked Jay Williams, who testified, he says, I don't know. I don't know what she was talking about when she talked about him hitting the wall.
Planning to publish a book, you could reach 3 billion more readers. If you've written a book and you're thinking about publishing it, you have to watch this video. Hi, I'm Sarah from Spines, the fastest growing publishing platform in the United States. If you want to give your book the best shot at success, there are a few things you need to know. The world has opened up. Today's global book market spans multiple languages and formats, with international readers representing billions of potential customers. Smart authors are publishing in multiple languages and reaching readers all over the world. Most authors start with English, but there are 5 major languages and dozens of international distribution channels where your book can be available. At Spines, we expand your reach globally across 6 languages and versions, from soft covers to audiobooks in multiple markets. Using the most advanced translation technology and top-tier international professionals, all at an unbeatable price. Want to publish your book? Want to hear more details? Leave your info and we'll reach out with a phone call to share all the information right away. Stay tuned.
It's Black Friday, and ContentCreator.com is having its biggest sale of the year, where you can get our AI creator course, our viral video effects editing course, and our editing template pack for a crazy low price. Let's start with the AI creator course. In just 2 days, I'll show you how to unlock the most advanced AI filmmaking and content creation tools without having to pay a cent in overpriced subscriptions. And with these tools, you'll learn how to create scroll-stopping videos that rack up millions of views, craft wildly profitable online ads that blow up your brand, and turn any creative idea into a powerful short film that looks like it belongs on a Hollywood screen. But it's not just AI filmmaking you're going to learn. With AI, you can create any image or graphic you can imagine. You can create full-blown viral YouTube thumbnails in seconds. Your website, your emails, your infographics, your entire business can be built with AI. People are using AI to build full content calendars in seconds. AI can come up with countless viral ideas. It can even script and storyboard your content, all while keeping your unique creative voice. You just need to know the right tools and how to use them. And good news for you, the AI Creator course will teach you all of this and so much more. It costs less than a date with your grandma, but like so many of our students tell us, it will blow your mind. Now, before I show you exactly what you'll learn in this course, I want to ease your mind with a few details. Number 1, this course was designed to help you avoid paying expensive subscriptions for AI tools. We show you the secret ways to access the most popular tools without having to sign up for monthly or yearly plans. Right away, this is going to save you tons of money. Number 2, this course is perfect for complete AI beginners and seasoned AI veterans. We have a beginner's crash course that gets you up to speed super fast, and then advanced sections that leave pros who use AI every day completely speechless. Number 3, this course is the only AI course that receives weekly content updates to ensure you are staying on top of all the rapidly changing AI technology. Many of our students say this is their favorite aspect of the program. And finally, number 4, this course has a no questions asked refund policy. The only reason we've been able to enroll over 200,000 students at ContentCreator.com is because our number 1 focus is helping people. If you don't feel like we've helped you, you get your money right back. Okay, let me walk you through everything you'll learn in this program. Up first, we have AI filmmaking. With AI, you can create practically...
That baby was terrified when you heard those people that said he cried and cried and cried when she was there, and he would stop crying if somebody else picked him up. That was his reaction. There's an old saying, something like, I never trust people who don't like dogs, but if a dog doesn't like a person, I trust them completely. And I submit to you that basically the same thing is true of an infant. Okay? You don't like babies, you don't like little kids, you don't think they're fun and I don't know, cuddly and snuggly and just wonderful, creatures, I'm sorry. If you're not that person, okay, and little kids know, okay, they know it's like, they're not going to go to that guy, they're going to go to that girl, they don't want any part of her, okay, and there's these things that have happened, and they happened when he was with her, okay, and in this case, ladies and gentlemen, this is really important. I'm going to try my best not to run out of time, and I'm sorry, I didn't mean to talk this long. In this case, he says she hasn't given any confessions or anything, like they don't have anything on her. I wouldn't have said that. Couldn't say that if he hadn't said it first. There's not. He's right. There's not. Okay. But there are implicit admissions that this case happened under her care, under her eye. Okay. There are implicit admissions that this happened. One of those implicit admissions is that she lied about what happened. Okay. The second one of those implicit admissions is that she changes the story. She creates essentially two separate events in talking to two separate sets of people to explain it. Okay. Third, she sends the text when she's at the hospital, and she sends the text to Paris. Yeah, she says, I babysit all the time, and nothing like this has ever happened. Okay? Okay. Now you parse that statement. You think about what that statement means. Okay? If I say, Stephen Douglas drives my lawnmower all the time, and nothing's ever happened to it. Okay? You know, until now. Right? I'm basically blaming Stephen Douglas. I'm saying this is different for Stephen Douglas. He drives my lawnmower. He doesn't normally break it. You know, but he did this time. Okay. If I say,
honestly, I tried the new bearskin hoodie, and here's the truth. This fleece is thick. It's made from 340 GSM of bearskin fleece.
if he breaks my lawnmower, okay, but I say, I've had this, you know, I have had this lawnmower for years, you know, and nothing's ever happened to it, okay? And then I turn around and say, you know, it's an implicit admission, and my analogy may not be very good, but I think that you get the point, okay? That she wasn't involved in this, if she didn't do anything, then the answer is, I don't know. Not he fell off the bed. Oh, no, what off the big bed? It was off the air mattress. No, it fell off the chair. No, it didn't fall off the chair, slumped over in the chair or something. Okay? I don't know is the answer if you don't do something. But if you do something, you're trying to explain it, trying to absolve yourself of attention and criminal responsibility, then you come up with other things and other people to blame, etc. All right. I've left this part for near the end, and that is talking about this offense, malice murder, okay, which is a separate charge than felony murder. Person commits the crime of murder with malice aforethought and causes the death of another human being. Okay. The court is going to charge you. I think that there's two kinds of malice. Express malice is a deliberate intention to kill, which is manifested by external circumstances that are proven. Implied malice is when there's no considerable provocation and circumstances show an abandoned and malignant heart. Okay. Ladies and gentlemen, there is implied malice in this case. There is implied malice. Okay. Now, I will not kill you, and the judge is going to charge you. Okay. He's going to tell you that we don't have to prove. Nobody has to prove that because foreplan, that they were planned premeditation. We don't have to prove premeditation. Okay, that's not part of the burden of proving malice murder. He's going to tell you that malice can be formed in an instant, and in an instant, a mortal wound inflicted, and it's malice murder. Right now, the reason that I'm bringing this to your attention is because you could reach the conclusion from this evidence, okay, that she either just lost it for whatever, that he left her with the baby again, he's going to get pizza and drinks, she's already mad because the baby's ruining her weekend and all that. Okay, and he left the baby, and the baby won't shut up. The baby was crying last night, half the night. She, had to get up and go to Paris's room till 2 a.m. and she's trying to play with the baby and wake him up. And now he leaves her with the baby again, and she gets out of the shower and he's crying and he won't shut up and she just flipped out. Okay, and maybe she doesn't. Maybe she doesn't intend, I don't think what I think doesn't matter. I'm not trying to prove and I'm not trying to suggest to you or make you believe that she looked at him and said, I am going to kill you. Okay. Like that. I do not I'm not trying to convince you of that. Okay. But I don't have to convince you of that. You define malice murder. Okay. What you have to find for there to be malice murder is that there's no provocation and the circumstances show an abandoned and malignant heart, that there's just a point at which somebody just goes too far. Okay. And when you use your hands or the edge of the bed or the edge of the desk or the floor or the wall or whatever the weapon was to cause this kind of damage, then the evidence is sufficient to show that she's guilty of aggravated battery and first-degree cruelty, felony murder, and malice murder. Now, Mr. Gamble has made a big deal out of, as he should as a lawyer, about reasonable doubt. And he says, this is reasonable and that's reasonable. Okay, the judge is going to charge you that we don't have to prove doubt beyond all certainty or to a mathematical certainty. We don't have to prove guilt beyond all doubt or to a mathematical certainty, right? And we don't have to disprove every ridiculous hypothesis or allegation made by the defense. Like I do not have the burden, frankly, of proving to you that this child climbed up on the dresser, and did a high dive on the floor, of his own accord. Because if he'd had one injury, not a whole panoply of them. Okay, I don't have to prove that. I don't have to disprove that hypothesis because it's not reasonable. It's just dumb. And when you look at it, you say this is not reasonable. Okay, so if there's some hypothesis that he's tossed out there that I haven't addressed, that doesn't mean that I failed to prove it.
Yes, he's using a Dorilla pillow. How can you tell? Have you heard about Dorilla Ergo? It's the cutting-edge ergonomic pillow that people actually look forward to laying their head.
You can take the evidence and analyze the evidence and say either this hypothesis has been disproven or not disproven, or this hypothesis is not worthy of attention in proof. When you consider the evidence, something else you take into account that there are two specific false narratives, okay? And these are not just arguments that are where somebody's off track on something, okay? These are false narratives, okay, that have been promoted to you since opening statement. In this case, I just didn't get to say anything about it until now. Since opening statement, okay, that the diaper, it's not said directly, but it is implied, okay, that the reason James Gibson threw away the diaper when he was examining the trash out of the trash bin on January 14th, the reason he threw away the dirty diaper was because there was a defense motion to test it. He files a motion and we said, we don't have it. It's gone. When I had to come to court and answer for it. Okay. That's not what happened at all. Okay. Gibson, as you heard from his testimony, made an independent judgment. Okay. Maybe he's even wrong. Okay. Everybody's wrong sometimes. There's not an agent that's good enough not to make mistakes. There's not a lawyer, a doctor, a cab driver, a carpenter, anybody else that's good enough that they don't make a mistake. And maybe Gibson's wrong. I would stand by the decision he's made as his fellow agent has done, but it had nothing to do with an expectation or worry or fear that it was going to be tested. What he had to do, and the fact that it was photographed, unfolded and photographed, doesn't mean that he saw it as being of special importance, but he wanted to hide it. Okay, if he saw it as being of special importance and wanted to hide it, he wouldn't have photographed it. The photographing is like everything else was in the trash bag, and he told you, he says, I opened up chip bags and cups and wrappers and all kinds of things. Okay, he photographed everything in there, not just the diapers. Okay, the second false narrative, okay, is that Jay Williams isn't legally JD's father, and maybe he's not, maybe he is, maybe he's not. Okay, but that has nothing to do with this case. It is a fact. It is a reference that is not even necessary to have been made in any context or circumstance whatsoever. Okay, it is designed to make you think that these people, the family of this child, do not deserve the same measure of justice that somebody would if they could say, not only is me and my wife, but I've got 9 DNA tests to prove it. This is my kid. Okay? Can't do that. Can't do that. Certainly can't do it now. Okay? I bet he'd love to have a paternity fight now. Love to. Say, yeah, I'll fight about it. And if I lose, I'll kiss him on the cheek and say goodbye. Okay, but he can't. Whether he's his father or not has nothing to do with anything. Petty contradictions due to different perceptions or memory lapses. And we talked about this before, and I'm not going to go into it much further. Okay, somebody says, oh, look, this is what I said. And they said, no, that's what you said. And it's been 2 years or more, and they're in 2 different contexts and 2 different, 2 different eyes viewing things, or 2 different sets of eyes. And sometimes they don't see things the same way. Failure to find or recover a weapon or other physical evidence at the crime scene. He says it can't be a crime scene because there's no blood. Okay? Some crime scenes don't look like the Manson family has been there. Okay? Some crime scenes, there aren't walls full of bullet holes. Some crime scenes, there's not anything in the room that specifically points to it and says a murder happened here. Okay? Why would he not look at the whole room looking for blood? Because he had just left the hospital and the child didn't have any external injuries. Okay? There's no blood because he wasn't bleeding. Whatever happened to the injuries that he suffered resulted from blows and force that caused him to have internal injuries that cost him his life. There's no weapon. Well, that really ain't right. I mean, that's really not true. Look at here. You heard testimony from the stand that if you pick the child up, Clark said it, if you pick him up and you held him by the shoulders like that, you slammed him down on a hard surface. And Clark said something like a desk or a chair. I think were 2 of the 4 or 5 things he listed. Well, see, there's a hard plywood chair, there's a desk, and there's another desk, and there's a bed, and there's other photographs in here that show the end of this bed, where there's a bed post about that big that sits on the corner of it. Okay, and the fact that I can't come in here and say we have a videotape of her smashing the kid against that chair, or, hurling him against the wall or hurling him against the bed, and the fact that I don't have a video of it, he's going to tell you that that means that you can't convict? Come on. I do have a picture. So you can see at the corner at the corner of the mattress right there. You can see it's like a metal bed post that sticks out of the thing. Investigative techniques, reason of doubt, joint interview. Okay, Samantha told you, Samantha Fort, I'm sorry, I didn't mean to refer to her by first name. Agent Fort told you that she had interviewed Jay Williams twice for 4 hours. She had interviewed Ashanti Burr before as well. I don't recall what the specifics of that particular interview were. What I would submit to you is that if it made a difference that in the third interview after their statements had already been made and sort of nailed down and it's just coming back for additional information, if it made a difference, then he would have played the interview and said, look here, this is why, they're in there together. This is what's messing up all these things. This is what's causing the testimony, the evidence to be tainted. Okay, it may be poor technique. Okay, it may be poor technique. It may be a violation of what you learned in investigator school to put 2 witnesses in the same room and talk to them at the same time for any period of time. Okay. But it doesn't create reasonable doubt when that's not the evidence that the case relies on. Declining to order or obtain irrelevant testing, the diaper, the vomit. Oh my God, I can't believe we're still talking about this. Okay, so the diaper. Yeah, what's his name? Dr. Busman says, it's like looking at a photograph that was taken under flash, and then put on a computer, processed through, displayed on this screen, which I'm sure has that true color under this light. Yeah, it looks red, right? Like he's not trying to fool anybody. He's not trying to joke about it. This diaper look like it's got blood in it. Yeah, it looks red from here. Okay, and then he's right. I believe that you saw that the significance of that was lost on Dr. Busman. Okay, he didn't understand why anybody was asking about a dirty diaper. Okay, the significance of it wasn't lost on me, however, which is why I came back and pursued other questions. He says, the state bent over backwards to get him to back up. No, I asked questions on redirect, which I'm allowed to do, which I'm authorized to do, which I'm supposed to do to clear things up. Okay, and when I go back and ask Busman, what I was going to say, he says, it doesn't have to be blood in red, something red. Well, you know what? If you look at that picture, and I'm not going to try to scroll back through it because I'll lose my place forever if I do, okay, of that child in the car seat coming from Parkwood to Albany when they went to meet at Chipotle. He's got a sippy cup, okay? It has a liquid in it that is as bright red as the top of this cabinet right here, okay? I mean, he's drinking, a big cup of red fruit punch or whatever, okay? So what if he pooped red? If it mattered, then it'd be a different story. But there's nothing to suggest that it mattered because there's no illness, disease, or any other process that could have ever been detected from a red poopy diaper that would have led to a conclusion different than this young'un died because somebody smashed him in the back of the head. There's a lot of audacity floating around this courtroom, okay? Jay Williams, okay, we're going after Jay Williams' parenting skills now. It's like, you didn't take your baby to the doctor for his 9-month and 12-month and 15-month checkups, Jay. The world is looking at you, buddy. Jay, I can't believe this. That baby's only 18 months old and weighs 25.1 pounds, and you have him in a forward-facing car seat in a sports car. My. The drama, the tragedy, the humanity. Okay? Whatever. Right? If you want to say that he needs a parenting class, I bet you he'd love to have to take one now. I mean, and if a trooper had seen him driving with a kid not restrained in a car seat or something, and pulled him over, he probably would have got a ticket for like reckless endangerment or something like that. And would have been prosecuted by whoever, would have been jurisdiction over it. Right? But whether those things are true or not true have nothing to do with the heart of this case and the evidence where it matters. Everybody in this courtroom's got a job. Okay? We're all here for a reason. The lawyers, and it's my job to prosecute cases. It's his job to defend cases. He's daggone good at it. And, the court reporter, she's sitting over here, she's taking down every word that's said. And we got bailiffs who are monitoring security and doing all those things. And a law clerk and somebody from the clerk's office. And everybody's here for a reason. I did this slide and I left off the judge. And it's again, sound like I'm being a smart aleck in doing it. But I was. I mean, I looked up and realized it's like, I thought it said judge. It doesn't. Everybody here has a job. Okay? And you have a job. Okay? Your job, ladies and gentlemen, is this. It is defined by the oath that you gave at the beginning of this trial. Judge Sizemore said, raise your right hand. He says, you will well and truly try this case and a just verdict give according to the evidence. Okay, there's two parts to that oath. There's two parts to that job. Part one is to well and truly try this case. And good Lord, y'all been great at it. Everybody's been here every day. People nobody's like, hey, look at that juror over there. They look like falling asleep. Things that we deal with, or waiting, day after day for people who are invariably late and don't come back from lunch and don't take notes on those things. Y'all been great. You've well and truly tried the case. You've done that part of your oath. But now it's time to do the other part of your oath. And that is a true verdict give according to the evidence. Your job is to do justice with this payment. That is your job. To do justice. Do justice not for him. Do justice for his loved ones. Do justice for your loved ones. Do justice for your community as a whole. Okay? Jury verdicts speak volumes. Jury verdicts speak to the jury, speak to the community. Okay? They speak. They say things to the community. People look at a jury verdict and say, wow, man, in America, they let people off for that. But they look at jury verdicts and they say, this is the wrong place. Wrong place, wrong time. Do that. You could send a different message. You could send a message and say, hey, look here, y'all. Everybody out in the world, look here. if you do a pretty good job of like not leaving blood, they'll kill somebody with your hands, smash them against the wall, crush their liver with your foot or your fist or your hand, whatever you need. Who knows? Don't know. Don't know. And the fact we don't know doesn't mean that it didn't happen. And it doesn't mean that it didn't happen at her hands. You want to send the verb? You want to send the message that says, hey, as long as you don't leave a lot of evidence on the scene, see ya. We'll walk you, We're going to require video. We're going to require video and confessions before we will convict. That's the standard you want to set. Ladies and gentlemen, that's the standard you set. As DA, I'll try to adapt to it. Okay? But don't let yourself think that you're not speaking beyond this courtroom when you go sit down to decide this case. Katie was 18 months old. If you want to do them right, you take this paper, you elect a foreman, and you put a whole bunch of X's down those rows that say guilty. A true verdict given according to the evidence. Yes, sir.
Sure. My plan is to give you the jury charge, which will take about 15 minutes, and then let you return to the jury room. Once you elect a foreperson and begin your deliberations, I'm going to let you decide if you want to go to lunch and break. I'll give you some more explanation of that when I finish. Or I'm going to let you, we could even order out some pizzas or something like that and bring it to you. But I'll give you a little bit more about that in a moment. Can y'all move, Madam Bailiff, if you'll move that to the right or the left? Yes, sir. Just so I can see everywhere. Thank you. All right. Ladies and gentlemen, we'll see if this works. Okay. Ladies and gentlemen, you're considering the case of the state of Georgia versus Trinity Poague. The grand jury has indicted the defendant with the offenses of malice murder, felony murder 2 counts, aggravated battery 2 counts, and cruelty to children in the 1st degree. I have previously read the indictment to you, and you have a copy of it with you. We'll have the original with you in the jury room. The defendant has entered her plea of not guilty to this indictment. The indictment and the plea form the issue you are to decide. Neither the indictment nor the plea of not guilty should be considered by you as evidence. It is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence presented. Then you must apply the law that I give you in this charge to the facts as you find them to be. The defendant is presumed innocent, presumed to be innocent until proven guilty. The defendant enters upon the trial of this case with a presumption of innocence in her favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offenses charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. When a defense is raised by the evidence, the burden is on the state to negate or disprove it beyond a reasonable doubt. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given arising from a consideration of the evidence, a lack of evidence, or a conflict of the evidence. After giving consideration to all the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you will be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. And facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. Your oath requires that you will decide this case based upon the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses and any exhibits admitted during the trial, stipulations of the attorneys, that is, any facts to which the attorneys have agreed with approval by the court, and any matters of which the court has taken judicial notice. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks by the attorneys, or questions asked by the attorneys. Where the parties stipulate testimony, documents, exhibits only, this is the nature of evidence. You may take that testimony as if it were given in court, and you may rely on it if you find it credible. However, either party may dispute such testimony by other evidence. You make all decisions based on the evidence of this case. And by the way, you will have this jury charge, or this written charge, with you in the jury room, along with the indictment, your verdict form, and all of the evidence that was admitted as exhibits, other than the videos. The videos will be in the courtroom. Direct evidence is that which may be seen or heard or otherwise directly sensed, such as by smell or taste or touch. It may be brought into court in the form of exhibits or the testimony of direct witnesses to such matters. It is evidence that points immediately to the issue in question. When direct evidence by inference points to an obvious, likely, or reasonable conclusion, even though that conclusion was not directly seen, heard, smelled, tasted, or touched, that is said to be circumstantial or indirect evidence. Circumstantial evidence is the proof of facts and circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in the light of your experience. It is evidence that only tends to establish a conclusion in question by its consistency with such conclusion or elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on circumstantial evidence, the proved facts must not only be consistent with the theory of guilt, but also exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher degree of certainty on the part of the jury to return a verdict based upon circumstantial evidence than upon direct evidence. Whether dependent upon direct evidence or circumstantial evidence or both, the true test is whether there is sufficient evidence or whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, then you must acquit. If so, you may convict. There is no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for the jury, to decide. Similarly, the jury must decide the credibility of the witnesses. In deciding this, you may consider all the facts and circumstances of the case, including the witness's manner in testifying, the means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility insofar as you are able to observe it. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. Testimony has been given to you in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. The defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. You would evaluate such testimony as you would that of any other witness. However, the defendant does not have to testify. If the defendant chooses not to testify, you may not consider that in any way in making your decision. The defendant is charged with a crime against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of an act and intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be in your discretion inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. This defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. The law provides that criminal actions shall be tried in the county in which the crime was committed. Venue, that is, the crime was committed in Sumter County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offenses. Venue must be proved by direct or circumstantial evidence or both. Now, this indictment has several counts. You need to consider these instructions and the facts of the case and reach a separate and independent verdict with regard to each count. Count 1 of the indictment charges the defendant with malice murder. For malice murder, the state must prove that the defendant caused the death of another person unlawfully and with malice aforethought. That the killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill without justification. You may find malice when the circumstances show that the defendant acted with the deliberate intent to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation and all the circumstances of killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, then that is enough for the killing to be murder. Premeditation typically means a prior decision or plan to do something. Premeditation is not an element of murder and does not need to be proven by the state for you to find malice aforethought. However, in determining whether malice existed at the time of the killing, you may consider any evidence of premeditation or lack of it. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's mind at the time of the killing. Counts 2 and 3 of the indictment charge the defendant with the offenses of felony murder. The state does not have to prove, for felony murder, the state must prove that the defendant caused the death of another person by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Aggravated battery and cruelty to children in the first degree are felony offenses, which I will define for you shortly. You may find the defendant guilty of felony murder as alleged in counts 2 and 3 of the indictment if you believe that she caused the death of another person by committing the felony of aggravated battery as alleged in count 2, or by committing the offense of cruelty to a child in the first degree as alleged by count 3, regardless of whether she intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as shortly after the felony was attempted or committed. The felonies have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. Count 4 and 5 charge the defendant with aggravated battery. For aggravated battery, the state must prove the defendant maliciously caused bodily harm to another person by depriving that person of a part of his or her body, by rendering a part of that person's body useless, by simply disfiguring a part of that person's body. For cruelty to child in the first degree, which is the charge in count 6 of the indictment, the state must prove that the defendant maliciously caused cruel or excessive physical or mental pain to a child under the age of 18. In deciding whether the defendant acted maliciously with regard to cruelty to a child, understand that malice is not ill will or hatred. Malice in this context means an intent to cause the pain without justification or excuse. Malice also means willfully doing an act while aware of a strong likelihood that the pain may result. And by no ruling or comment that the court has made in the progress of this trial has this court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendant. Your verdict should be a true verdict based upon your opinion of the evidence according to the law given to you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, economic status for or against the party. You are only concerned with whether the defendant is guilty or not guilty. You are not to concern yourselves with punishment. One of the first duties in the jury room will be to choose one of you to be the foreperson. The foreperson will manage your deliberations and will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind, talk with each other, and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case with your fellow jurors. Don't hesitate to change an opinion if you are convinced that it is wrong. However, you should never give up an honest opinion to be congenial or to reach a verdict solely because of the opinions of the other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are also not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. I remind you, you're not to have phones in the jury room. These rules apply not only to in-person communication, but also to communication research using cell phones, text messaging, websites, blogs, or social media of any kind. Now, as I mentioned, this indictment involves multiple counts. You should consider these instructions in reaching your verdict with regard to each count independently and separately. We have provided you a verdict form with regard to that will allow you to express your verdict with regard to each count. So using the verdict form, for example, with regard to count 1, for example, of the indictment charging the defendant with malice murder, if after considering testimony and evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Sumter County, Georgia, did on or about January 14, 2024, commit the offense in count 1 of the indictment, you'll be authorized to find the defendant guilty of the offense, in which event, with regard to count 1, the form of your verdict would be, we, the jury, find the defendant, and you would check or X guilty. And then On the other hand, if with regard to count 1, you do not believe that the defendant is guilty of the offense of malice murder as charged in count 1 of the indictment, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict with regard to count 1 would be with the jury find the defendant not guilty, and you would under count 1 X not guilty or check not guilty. Again, you should independently and separately make such a determination with regard to each count of the indictment. Whatever your verdict is, it must be unanimous, that is, agreed to by all 12 of you. The verdict must be in writing and signed by one of your members as foreperson, dated and returned to be published in open court. Now, in just a few moments, I'm going to ask you to retire to the jury room. Again, do not begin your deliberations until you receive the indictment, the verdict form, and a written copy of these instructions, evidence that will be presented to you in the jury room. As I mentioned, what I want you to do is once that happens, so you're foreperson and either begin your deliberations, or you can start your deliberations. And if you want to take a lunch break, let me know. If you want to start your deliberations and have us order some pizza and bring it into you, we can do that because it's right around lunchtime. But I don't want you to rush. If you'd rather go to lunch and come back, that's fine. If you would rather have lunch as you deliberate, that's also fine. Whoever the foreperson is needs to make sure that the jury is not deliberating unless all 12 of you are in the jury room. So if, in other words, if somebody steps into the restroom, you should suspend your deliberations. Okay. Or if you take a break, you should suspend your deliberations. With that, I'm going to allow you to retire to the jury room. And once you begin, once you get the evidence, the verdict form, the indictment, and the instructions, you can elect a foreperson and begin your deliberations. Wait, we have 3 alternates. If you wait just 1 second. I've got it. Jacob Cromer, Johnny Lassiter, and Sadie Golden. You 3 are alternates, and we're going to sequester you separately. But all of the instructions I've given you about discussing cases and things of that nature apply. Y'all are not yet able to discuss the case or do any research or anything of that nature, even with each other, unless you're brought into the jury room. But I do need you to remain in the courtroom. We have a different room. Judge Rambo has a state court office over here, and y'all will stand there and just remain available. Everybody else can retire to the jury room. All right, if y'all come up and make sure all the exhibits that are going back are ready. Mr. Bland, well, first Chet, if you'll grab that, please. Is there any exception to the charge from the state?
Subscribe to at Southwestern and hit the bell for when we go live.
Okay, that'll be fine.
Subscribe to at Southwestern and hit the bell for when we go live.
I don't think I put them in where. Stephen, are my exhibits all in?
Thank you for watching at Southern Sin, your home for true crime. Smash the like button now.
Except for like. What in the world is that about? Hitting the wall. I asked Jay Williams when he testified, he says, I don't know. I don't know what she was talking about when she was talking about him hitting the wall. That baby was terrified of her. You heard people that said he cried and cried and cried when she was there. He would stop crying when somebody else picked him up. That was his reaction. There's an old saying, something like, I never trust people who don't like dogs.
Well cut. And I'm Michael Ayala. We're both here today giving you your front row seat to justice. And we begin this hour in Georgia. The jury deliberating the fate of defendant Trinity Poague now has a question.
Poague is the former pageant queen charged with murder in the beating death of her boyfriend's son, J.D. The 18-month-old was found unresponsive in Poague's college dorm room.
Thank
and
you for
later,
watching at Southern
that
Sin,
baby right
your
there on
home
your
for
screen
true
died at the
crime.
hospital.
All right,
Smash
let's
the
go
like
right into
button
court
now.
now and hear the jury's question.
Courts one, I'll mark this court two. On court one, I had written, somebody had written that we were going to send back a note asking what they wanted as far as food goes. I scratched that out. I told them not to send any other note back. But this court two reads as follows. What are the following? Count 2, felony murder. Count 3, felony murder. Count 4, aggravated battery. Count 5, aggravated battery. And then it says EG is 1 for the head and is 1 for the liver. So that's the question. It's signed by the foreperson who apparently is Mr. Phillips. So I think the only response, my impression of what I should do back in, tell them they have to read the indictment. I can't answer their questions about this. And they have to read the indictment and they have to consider my instructions as a whole and make a determination as to each count separately and independently, considering my instructions.
Do they have the indictment?
Yeah. Of course they have the indictment. I mean, okay. Yeah, right, man? Yeah. Yeah, I saw y'all put it on top of it. So I'm not sure. I mean, I know off the top of my head, count 2 is felony murder based upon aggravated battery. Count 3 is felony murder based upon cruelty to a child. And then the aggravated batteries are, one is for head injuries and one is for the liver injury, I think.
Yes.
But I don't think that's my place to tell them that. I think they have to read the indictment and make a verdict, considering all the evidence and everything that has been instructed to do. Do you agree with that, Mr. Mayor?
I don't think that that the court should interpret the indictment for them, if that's what you're saying.
You agree with that, Mr.
I think that
I do, yeah. I do. All right.
I think you may
let's bring them back in.
just tell them that reread the indictment. That information is set out in the indictment, but I don't think you should interpret it for them.
All right, so while they bring the jury, I want to bring in our guest here this hour is criminal defense attorney Forrest Miller. Forrest, you heard what was going on there. Essentially, they're trying to figure out these charges. There's 2 felony murders, 2 aggravated battery charges. There is that top charge of malice murder. Maybe they kind of skipped over that or decided that wasn't the case. We don't know for sure. What are your thoughts on what?
Subscribe to at Southern Sin and hit the bell for when we go live.
All right. Mr. Foreperson, does the jury have a verdict? All right, if you would pass that to my bailiff, please. All right, Ms. Poague, if you would please stand. The verdict reads as follows as to each count. On count one, as we the jury find the defendant not guilty. On counts 2, 3, 4, 5, and 6, the verdict reads we the jury find the defendant guilty. On felony murder, 2 counts, aggravated battery, 2 counts, and cruelty to child in the first degree. Y'all can have a seat. Ladies and gentlemen, it's been a tough week for you, I'm sure, and I know that you probably had a lot of places you would have rather been this week than here. I do want to thank you tremendously for your service. You have shown up, you've been on time, and you've paid thorough attention.
Thank you for watching at Southern Sin, your home for true crime. Smash the like button now.
The fact that you've deliberated over this, you've looked at this very closely. So that your county appreciates the work you've done, and you'll receive a stipend. It's just a token of the county's appreciation. You are free to leave for the term. You're also free to, you can certainly step back into the courtroom through the other door if you wish to, or hang around if you want to speak with the lawyer. But you don't have to. You don't have to talk to anybody. You're welcome to leave at this time if you prefer. If you do, turn in your badge on your way out and make sure that your notes are in the jury room. And I really appreciate it. Y'all are free to go. I'm being told that the state and the defense agree that the sentence the court is going to impose is for counts 2 and count 6.
Yes, sir. I advised Mr. Gamble that after doing some additional research, or some initial research rather, on that particular question, that I think that 4 and 5 would merge with count 2, and that being the case, the state's position is the court should sentence on count 2 and count 6, which I understand is the defense position as well.
Correct.
Yes.
Yeah, that's what I was finding too. I had never seen a case where you could back a charge out of the felony murder, even if it was, of course, there's very few cases where more than one felony are charged in a single count of felony murder. But at any rate, then count 3 will will be vacated. Count 4 and 5 will merge with count 2, and count 6 is a standalone offense based upon the merger of count 3. I mean, the vacation, the fact that count 3 will have to be vacated. Is that correct?
Yes, sir.
All right. I'll hear from the state concerning sentencing as to count 2 and count 6. And of course, if you want to present any witnesses, you certainly can. And I believe the sentence possibilities are life on count 2 or life without parole. And on cruelty to children in the first degree, the sentencing range is 5 to 20. 5 to 20. Okay. All right. All right. I'll from the state first.
The state proposes that the appropriate sentence in this case would be a sentence of life in prison on count 2, with a sentence of 20 years consecutive on count 6. I understand that Ms. Poague is very young. I think this is the terrible tragedy of these kinds of cases. I have a baby as a victim, and who was at the time a teenager as the defendant, and I think that the jury's verdict. It's not always very possible to get an interpretation of what the jury might have been thinking. But I think if you look at the way the verdict is structured, that it suggests to me, at least, that by finding a not guilty on malice murder, that there was a belief that there was not evidence of a specific, essentially a specific intent to kill or a deliberate intention to kill, and that would be the distinction between count one and the remaining counts. And so, in my view, if I accept that as a finding of fact, from my perspective in proposing a sentence, if I consider that or accept that as a finding of fact of sorts, that there's evidence of malice, that there's evidence of disregard, conscious disregard for the consequences of her actions, then I feel justified in asking for consecutive time. But if I do not believe that the evidence supported this jury in making a finding of a deliberate intention to kill, such as would support a malice murder conviction, then I'd feel constrained to leave the recommendation at life without parole. I mean, at life in prison as opposed to life without parole.
All right. Do you wish to present anything? Anybody wish to say anything from the family, or are you presenting any testimony?
No, sir. We're not presenting any testimony, and I'm not. The father of the child is not father and are here, of course, but I'm not asking them to make statements to the court, and I've told them both that they could if they wanted to do so, but
okay. Mr. Gamble.
We recognize felony murder. I don't think there's recommended life with parole. That's as lenient as the sentence could be out of that particular charge. I don't think you can go below life in prison for a felony murder charge.
Right.
So we don't dispute that. We would ask, though, Your Honor, the cruelty to children, they're asking 20 years. If you put that on there, you're coming very close to being life without parole, in that she will not come up for parole current for 30 years and then add 20 more to it. Would be very close to her entire lifetime. And we would ask the court to consider the evidence, and the general what the whole circumstances were. She was 18 years old at the time, a young girl that had not had any trouble with the law, was doing well. Now, obviously, she's accused of a horrendous crime that we fought out in court, but we accept a verdict, whether I agree with it or not. So she has to now face what the consequences are of that. But it should not be so severe. It would be akin to life without parole. And that would be what happens if you make this consecutive serving time sentence. So we would ask on the cruelty to children that it run concurrent with the life sentence that she is going to be imposed on her felony murder. So felony murder plus 20 years, but run concurrent with the felony murder charge. Yeah.
All right, Ms. Poague, if you'll stand up, please. I don't do a lot of speaking when I'm passing the sentence. I've heard the case, and I've considered the tragedy on the left side, on my left side, and on the right side. And there's a lot of tragedy to go around here. The whole time that I'm hearing your case, I think about what the appropriate sentence would be. And this conduct all led, in my opinion, to the defense of felony murder, even the charge that, would have merged with count 3, but does not, because count 3 is vacated by count 2. That's a lot of technical jargon. But the bottom line
Subscribe
is
to at
you're
Southern
going
Sin and
to
hit the
receive a
bell for
sentence
when
of
we
life
go
in
live.
prison, which is the appropriate sentence for the conduct that you have been convicted of. And that is going to essentially be the sentence that the court passes in this case. You will be sent on. So on count 2, I sentenced the defendant to serve life in prison. And on count 6, I sentenced the defendant to serve 20 years in the state penitentiary. Those sentences will run concurrent. I do wish to advise you, Ms. Poague, that you have 30 days to appeal. You also have 4 years within which you could seek habeas corpus. I hope this can bring some closure to the family. It's just a complete tragedy. And I hope that you can, in your older days, have some sort of life after serving the sentence, and life while you're in prison. You just have to make the best of it. But that's the sentence of the court. Wish everybody the best.
Forward it to Mr. Gamble for review, and then to Your Honor.
Thank you.
Subscribe to at Southern Sin and hit the bell for when we go live. Thank you for watching at Southern Sin, your home for true crime. Smash the like button now. True crime just got darker. Catch the full episode on the link above. Subscribe to at Southern Sin today and hit the notification bell for more live original episodes Wednesdays at 8 p.m.